Appreciate your service, Doc.
Okay, that's fine. There's certain things that
Appreciate everybody checking in. Please hit that like button on the way in. I see you, I'm girl.
Yeah, no cups.
I think your volume is on. And how you doing, my brother?
I'm good.
Yes, sir. Spider last, man. That was something else, bro. Tina P, I see you.
No, you're good. It was so strong. I got that with me too in case we go along. Everybody ready to go?
All parties ready?
Yes.
We're reconvening the Township of Thornton Electoral Board. I'm Ellen Raymond, the chairwoman.
Madam Chair, would you like me to take over?
Yes, please.
You got it. All right, we're gonna do the roll call right now. We've got Chair Raymond,
Present.
Member Osfeld,
Present.
and Member Swanson.
Present.
We have all members present, we do have a quorum. Today we are here to hear the case of Supervisor O2C, Keith Price, Michael Smith, and Jerlene Harris versus Napoleon Harris. And are the parties ready to proceed?
Yes.
I do have one quick order of business. We do have two
Oh,
decisions
the
to
queue, I
issue.
see.
The parties prefer that we issue the decisions at the end of the meeting, or we can move that up to now.
I think we should push it to the end.
Is that okay with everybody? Okay, we'll do that, that's fine. Okay, so we are here to start off the hearing on that case. The objector has filed objections, just for the benefit of the public, the objector has filed objections challenging the residency of Napoleon Harris III, and it is the objector's burden of proof, so the objector can get started.
We do have some preliminary motions.
Okay,
The first would be a motion to exclude witnesses. This matter is also being live streamed right now by
Thank you all.
YouTube, and
Yeah,
I see
appreciate you.
witnesses
Bless
that are
you.
going to be present. So how does this board seek to exclude them from using and viewing YouTube while this matter is proceeding?
no, that's a fair point. I guess we could, is there room available at the township that we could possibly sequester the witnesses in and ask them to leave their electronic devices someplace? Anybody from the township? Okay, let me take a quick break and see if I can figure this out. Just bear with me one moment.
Yes. That's your one to get 'em. I'm not waiting. Even Judge Bertucci might be in the apartment. I have low blood sugars. I eat constantly.
Congratulations.
He was so nice.
That's right.
Oh, If I don't trip over, if I can't see course. Stay there. They could, I mean, that's what I wanted. And then, instead, he filled my bottle with the water fountain. Don't waste that. It's like, what's the worst thing? The water fountain downstairs. Did I give you one more comment for that? Now look at the flowers.
Thank you.
Well, yeah,
Oh, there's one. Oh, yeah, there's I don't know if that door's open. I know.
What, go.
You got a Republican, a fake Democrat, a Muslim. I like this too.
So we do have a room to put the witnesses in. What we could do is have them lay their cell phones outside of the table before they go in.
We just have
And
the
sequester the witnesses. I'm sorry.
No.
maybe just have on the garnish that, because we're gonna have people back there for hours, they might have other things they need their cell phones for.
And what do the parties wanna do? Cause I do understand the concern, you know.
and if they have children, we can't have them do stuff.
Okay, that's fair. What does the board wanna do? Do we want them to allow them to have their cell phones, but just tell them that they can't stay off social media, stay off YouTube, do not watch anything?
What's up, man?
Is that fair?
I have an issue with it, is that, the events of Thornton Township seem to be one of the top rated things on social media. We are here today in this room because of security concerns. And quite frankly, people could text stuff to people. I've had cases where witnesses have received virtual text messaging from a hearing telling the witness what's going on. I'm sorry, the phones need to go away.
If I could hop onto that, some of this is being recorded live stream. So even though witnesses may be in another room, the witnesses that are here are being live streamed to the public where people can watch it. It's problematic.
Well, let me ask, how many witnesses do we have that are here right now? We got you, and what's your name, ma'am?
My name is Julie Harris.
Julie Harris, okay, you're one
And
of
I'm
the,
gonna need a soft-seated chair.
well, you're one of the objectors, so you're a party.
Yes, I am.
So actually, as a party, she does get to stay here throughout the whole time. Mr. Smith also would get to stay here throughout the whole proceeding because they're parties to the litigation. So are there any
Mayor
other?
Clark is the only witness that is not a party. that's here.
Okay,
And Mayor Clark is in our case in chief, which would lead to my.
Is that Mayor Clark, candidate supervisor?
Correct.
Anyone?
correct.
Also Harvey resident.
So would the parties be okay if just Mayor Clark went in their room, and if he's the only other witness?
That's fine with me.
Okay, Mayor Clark, would you mind going in that room and maybe giving your cell phone to your attorneys, and if there's an issue?
Yeah. As long as you understand that if the city burns down, you guys are responsible.
Well, that's what we're getting to tell you, give it to your attorney's office.
Where you want to go?
And for the record, Mayor Clark has tendered his telephone to his attorney, Carrie Lynn Carecrafter.
Also, we have Mr. Suppet, you can put him back there also.
Okay. All right, is that agreeable? And then Mr. Suppet also. Thank you. Do you want us to hold it up here? Yeah, I'll put it on the table over here.
Who was that witness?
What was,
His name is Richard Suffolk.
We don't see on this witness list.
He's not on the witness list because he's actually a person being produced in response to your preliminary motion that we didn't receive until last night. That alleges that checks were not served, he has knowledge about that.
So you can put him in the room at this time, while we argue the motions.
Any hard copies? Did anyone deliver to me any hard copies of witnesses, or subpoena documents, because I didn't get them, if you did?
No, we are told to bring them here.
So are you giving them to us now?
When we start the hearing, we will, as far as introducing exhibits.
Thank you.
Request was made to sequester witnesses. Had some discussion about that, just for the record, so it's clear. I will move, just so the record is clear, we've had a motion to exclude witnesses. We've had a discussion on the procedure for that, so I make the formal motion. The witnesses will be excluded until the end of their testimony by all parties. Cell phones are not allowed back in the room, so there's no way of getting in. So the motion is to grant the request to exclude witnesses pursuant to the terms that were arranged.
do we have a second on that motion?
Second.
All in favor?
Aye.
Motion carries.
One other point, we've kind of staggered the arrival of our witnesses based on when we'll be calling them, so there might be people later arriving. So if they come in during the hearing, they should be directed to be excluded also.
Yes, if you can indicate to us when they come in.
But then we have the same problem, right, that you brought up, that Steve brought up, that they're at home watching the live broadcast. So they're not really
Yeah, that's a matter for cross-examination, they come on, have they done that or not, and then it will go to the weight and testimony.
Yeah, I mean, if they're not here, we can't.
I know,
do anything
I'm
about it
just
right now.
pointing
So,
out.
yeah, I do think that.
So I thought it was security.
Well, as a board, you guys can always start off
there, you say you have
the
police officers.
examination and say, have you been watching any of the proceedings today? And, you know, we as a board can ask those questions. So, and you guys can put that on the record, and I think that would be a fair way to proceed.
Okay, is that okay with candidates council?
We will have to, if someone walks in, we'll deal with it, and on cross-examination, we'll deal with it.
Okay, thank you, everybody.
The second topic I had was scheduling for today. We have witnesses that, you know, I don't want people to be swarming this place and sitting around for hours, so can we get a sense of Mr. Mullins' schedule as to the number of witnesses and how long he thinks it's gonna take to?
I think that's fair. I think we should ask that, honestly, of both sides, you know, to have an idea of, you know, how many witnesses do you guys intend on producing? How long do you think your case in chief is going to take? And then, you know, obviously, we'll ask the same question of the candidates.
And then like last week, we're cutting it in half, and you did a great job showing it.
So we have at least 4 witnesses that we will be calling today. There are several others who we believe have told us they will attend, but I'm not certain they will. And then we'll have some documents that we're gonna ask to introduce into evidence. So I would say a couple hours.
Okay, and candidates council, how long do you think you're,
I don't know how long cross-examination is gonna take
that's
for each
right.
of these witnesses.
How many witnesses does the candidates council intend on introducing? And I know that might change depending on, of course, what happens in the case in chief.
Right. We know that we have subpoenaed 4 witnesses. One's gonna be their first witness, and then we have Mr. Thornton. I'm more concerned about him traveling down here, especially how bad the weather is, and there's flooding on 94 and
In 290.
Yeah, 290, there's flooding everywhere
The
right
Bishop
now.
4, the Dan Ryan,
So
yeah, it's kind of
I
a
just
hot
want to give
mess.
him enough time.
Okay, All right, do you know, did you schedule a specific time for him to be here, or are you
I was,
gonna keep contacting him? and-
I'm contacting him
Okay.
now to tell him maybe like 4 o'clock, but how long are we going till today?
5. Is that an agreement? And so you need to also remember, we need to discuss between ourselves and render a decision, hopefully by 5, so that doesn't mean evidence until 5. Also, for disclosure's sake, I'm not sure what role Michael Dorff plays, but you can see in his resume that you provided, I share a ICL chapter that we read together. So I don't know if I need to disclose that or if that makes any difference.
I don't think that makes any difference one way or the other. I think that's completely independent of this situation, so.
I don't know what he's being called, but I was happy to see his name. A brilliant writer. Read his half.
Manager, I also think that on his CV, he also shared, I think, an article with Mr. Mullen, so.
Oh.
Mike Dorff.
Mike Dorff,
Co-author of the election law chapter on ethics.
Oh, and our, state and federal remedies, our election chapter. I guess he's writing the whole book.
So I will tell Mr. Dorff to get here by 3:30.
Yeah, I would say that should be fair. Okay, so any other preliminary matters before the candidates, before the objectors start their case in chief? Yeah, we have
Yes,
the motions,
yeah.
correct?
Yes.
Yeah, we have 3 motions in regards to the evidence. For the record, Bert Ortelson, one of the attorneys for the candidate. I think Mr.
Are these microphones working? I'm having trouble hearing Bert, I'm sorry.
That's right, I think you might just have to move it a little closer, Bert.
We have 3 motions. I think Mr. Seckler's going to do the first one on 237 motion, and then I'm going to do the one to asking the board to strike the submission of all the hearsay unmarked exhibits. But I would yield, if it's okay with the board, to Mr. Seckler to argue the first motion. We have hard copies, if the board would like hard copies.
Yes. Which are we hearing first?
The first matter, that this is Ross Seckler, SECLER, candidate. The first matter that we would like the board to address is untimely and frankly invalid Rule 237 notice produced. We filed a response and objection there too. And this gets to the fact that on a document that was entitled a Rule 237 notice produced was emailed to the council, the Electoral Board, as well as council to the candidate from the objectors council. That was on January 29th at 9:41 p.m. saying that they want Napoleon Harris III to be here and to produce all these documents. As the board is well aware, the objectors requested and were issued a subpoena, among others, a limited subpoena for Mr. Harris. Under the board's own rules, service of those subpoenas have to be done in the same manner in certain court. The objectors failed to do that in any way, shape, or form. The objectors, in proving that, the objectors on the 28th of January tried to reach out to council and said, will you accept service of these subpoenas on behalf of Mr. Harris as well as his wife? He said, no, you have to follow the rules. You have to follow the law. Just just like they did not accept service or didn't volunteer to accept service on behalf of the objectors, and for the subpoenas that we were granted as the candidate and we issued and did properly serve, they did not, we would not, and just agree to limit the rules and allow them to shortcut the mandatory procedures to compel someone to appear here. The board's rules of procedure are clear on this. I believe at the first initial hearing, and I apologize that I was not here at the initial hearing, but at the initial hearing, there's a long discussion about notices to produce, as well as subpoenas, and the key and clear thing was all of that had to be requested in advance and at the same time, within the agreed upon timeline. They did not request a notice to produce, they requested a subpoena. They would issue a limited subpoena, and they did not serve a subpoena. They attempted and are going around, they're trying to backdoor and compel someone's appearance here when that does not have proper service and notice of those, to be here with those documents. This is, it is just an it exemplifies, and as will be discussed with other objections and responses, as was mentioned and discussed at the last hearing in this matter, this exemplifies the malicious mischief of this case. They don't want to input the resources to actually do and comply with the board's own rules. They don't want to comply with the Supreme Court rules. They want to just shortcut that and spend as little amount of time and resources as possible in order to waste this candidate's and this board's and this township's time, money, and resources. That is it. They don't want to do the work. They want you to do the work. They want us to do the work, and that's it. And that is my big problem. They have the burden of production, and they have the burden of proof. They have failed that, and this request is demonstrative of the bad faith nature of this objection, and we request that it be denied and rejected. And further, we would mark that
You made your point.
Yes, thank you.
And objector, did you bring us hard copies of that supplemental request? We have these hard copies of your objection.
Copy of the notice to produce?
I have a copy of the notice to produce.
Another one.
We emailed them to the board, we brought copies of everything else, so I'm sure that you have that. All it is, it's a notice to just produce Mr. Harris and request the same documents as were approved by the board in the subpoena.
So if I can just ask a question before you speak, I thought a lot of the documents you asked for in the supplemental request were already in the list to be provided by the candidate?
They are. We got the subpoenas on Saturday. We had our service processor go out Sunday, Monday, and Tuesday to both addresses, the one in Flossmoor and the one in Harvey, and they were unable to effectuate service. There was no one present there for multiple attempts. And at the Harvey location, I believe the door would not be answered. There was someone there. That's when we asked them if they would accept service, and they said they would not accept service. Mr. Harris is a party. We talked about doing a 237 notice at the last hearing. There was no deadline set for that. We agreed to do a subpoena instead, and we made multiple attempts to serve it, and were not successful. And the problem here is that Mr. Harris is a party to this case, right? He's not some third-party witness that is not outside the jurisdiction of the board. And it is unfathomable to me that the candidate not appear to be cross-examined to testify on his residency. And he's proffered an affidavit that they are seeking to admit. So basically what they're trying to do is have their cake and eat it too. Have him come in and provide us an affidavit setting forth what he believes to be the facts about his residency, and not come in and be cross-examined, and he's a party.
Is that because of our expedited timing that the senator's in Springfield doing official?
Well, he was not in Springfield. We had people looking for him in Springfield. We had two senators who,
Excuse me, I have to interrupt because he was in Springfield. And I talked to him in Springfield, and I talked to aides in Springfield. So that is a misstatement by Mr. Mullen.
Well,
The senator was doing his job in Springfield.
And we have also produced the record.
several of the senators said he was not at the caucus meetings. We had someone trying to find him and serve him in Springfield. I had two senators text me, and I have the text saying that he was not at the caucus meeting. He was not at, any of the hearings.
And we produced the Senate calendar, and the Senate is not in session today. So really, their motion is arguing that our request is unreasonable. What the board needs to look at is its rules. It needs to consider if there's any bias here. We believe there's actually prejudice to the objector in this matter, and whether or not we're acting in good faith. And I would submit that, first of all, this case is not happening in a bubble, right? I mean, the bench knows this because one is a practitioner who's handled election cases, two are other election attorneys, and we're in the middle of an election season right now. So we received the subpoenas on Saturday. We had to disclose our evidence and witness as of yesterday. So that gave us 5 days to effectuate service of the subpoenas on this. Now,
Why did you not anticipate the difficulty, given Mr. Harris's time in Springfield, and pursue initially a 237 request, which under our rules could have been allowed had you done that?
well, the election bar is generally collegial, and we are very familiar with and have numerous cases against opposing counsel. And we voluntarily were producing our people. We didn't receive a request to waive subpoenas. Our people were making themselves available. We did contemplate it could possibly be hard serving them, so we hired 2 different process servers, and we had people looking for them in Harvey, Flossmoor, and Springfield. And I mean, we can produce affidavits to that effect if the board wants them. But it also, it's a party to this case who has been very vocal in trying to claim that he lives somewhere other than where he does. We fully expected him to come forth and testify on his behalf.
So this has been why I filed the motion strike and dismiss. The burden is on the objectors, okay, to come forward with some evidence. And I keep using the term malicious mischief. And when you go through the evidentiary materials, if they want me to stipulate that Mr. Harris has a lovely family, I will stipulate to it. But there are photographs upon photographs of their children. And I'm supposed to weed through that. I sent them, and this what becomes very important here is, I sent them an email. Let's talk and go through these exhibits. They didn't do it. We asked for subpoenas for their witnesses, all right? The only way you can compel appearances of people by statute is by the issuance of subpoenas. I went over the Daniel versus Daley case. That's the only way you can do it. The burden is on them. Collegiality, excuse me, no one responded to my emails about, but what I'm sitting here going is, they had a time period to submit the request. They requested a subpoena. The senator had, in fact, I believe there are actually, because I watched one, a session where he's sitting. So I don't want to hear this nonsense about, oh, he's in Springfield, we couldn't catch him. These are expedited proceedings, extremely expedited proceedings.
And to go back to my question, isn't there a lot of duplication in your request of documents we already have on the document list from the candidate that they're providing?
They have not provided them. That's what we were requesting in pursuant to a subpoena. We did not believe there was a deadline established by the board for notices to produce. I believe the case management order we had was a deadline for the subpoena requests. But I will also point out that under the board's rules say, hey, we permit discovery, we follow the rules of civil procedure, and we will not strictly follow these rules because we know these are expedited proceedings. So I believe in this instance, we have good faith for requesting the documents that we've requested here.
Can you confer with candidate and see how many of these documents overlap with what they're already providing?
Well,
Because I don't have a hard copy to check it on.
But the candidate isn't here to testify and be cross-examined, so they want to introduce an affidavit of the candidate
Yes.
indicating the facts that he believes are true relating to his residency without being cross-examined. And he's a party to this case, he's not a third party, the board has jurisdiction over it.
No, so, no, just the whole statement, and the whole argument that we follow the general rules of civil procedures and practice, that's true, but it does say that except as modified by board rule. And the board rules explicitly talk about subpoenas, and frankly, section 10-10 of the election code gives the board one explicit power in this regard. It says you can issue subpoenas by majority vote of the board. It used to only be for the chair, but they changed it to majority vote for other reasons. But by majority vote, that's how you can compel, and then if people don't follow those subpoenas, those can be enforced in circuit court. That is how this board has power to compel attendance. In the initial hearing, my understanding, there was a video that there was discussion about notices to produce as well as subpoenas. And I believe, Madam Chair, you said that's fine as long as they're all submitted by the deadline. So that is the key. They did not submit a notice to produce. They submitted a subpoena. They failed, and that is by its nature more adversarial and frankly has a sharper tooth. You can enforce that if he wasn't here. They did not serve him with the subpoena. They attempted to file an untimely and bootstrap something labeled a 237 notice because they could not and would not serve him. As the rules provide for it, the statute provides for it, and all of this other argument is just irrelevant.
Has everybody made their position and we're ready to discuss?
Well, I would just add that Rule 9 actually says that it does apply the standard traditional rules, and, quote, because of the nature of these proceedings, the electoral board shall not be bound by such rules when appropriate. Now, I would disagree that there's more teeth to a subpoena, because there's a consequence under the Code of Civil Procedure for a party's failure to be produced pursuant to a notice to produce. And we would be prejudiced by his failure to show up in response here, and we're entitled to a negative influence, both under that and under the pattern jury rules, which albeit are not necessarily disclosed here, but when you have a notice to produce and a party does not respond in conjunction with that, then there's a negative inference that needs to be drawn from it. There's nothing in here prohibiting us from issuing this. And we are prejudiced in his ability to be there. And if they're arguing that we were not diligent in service, notwithstanding their refusal to provide involuntarily, then we would request additional time to suspend this we'll produce the rest of our case, but for leave to have additional time to serve him with the subpoena. Note though, one of the constraints that we had wasn't due to the parties, it was due to the unavailability of one of the members of the electoral board. So we kind of were under a highly compressed schedule because of that. And I know people are doing a public service when they serve on these boards and have pre-planned vacations and other conflicts, but just putting that in the record, because that is, if this case spilled into next week, we would have the opportunity to the additional days to attempt to serve this. But the fact that we didn't get the subpoenas till Saturday, and then there was a deadline for us to disclose all our evidence within 4 days, when we are also election law practitioners that have had briefs during the appellate court and the circuit court, other electoral board hearings, everything else during those 4 days. It's not a lack of diligence. It's not a lack of good faith. And this is not a case of malicious mischief. It's a case of carefully designed deception. And that will become apparent as we proceed with these proceedings when we hear some of the testimony we do have available to submit. So we think that because of the prejudice to us in this instance, because of the compressed timeline, because there's been no evidence of bad faith, and because we have been acting with due diligence, that we should be allowed to have the party produced. It's not, like you said, it's not some third-party witness that we don't have access to, it's a party to this litigation.
And do you have, for the record, for us to enter the proofs of attempt to service and the failure to serve?
We did attempt to have our process server today, but he was subpoenaed in a different case that he had to depose in. If we can get that, so, let's see if we got it here.
For the record, there's been, we filed our proofs of service of our subpoenas, which is what's required. We've not received any proofs of service or affidavits from the objectors.
Well, we couldn't file proof of service for someone we couldn't serve. That wasn't what you asked for, right? You were asking if we had evidence from our process server that we attempted service. And it was
Yes,
not.
don't you get a paper saying the date and time?
Well, he was-
And we
still
filed
attempting
those
as
too
a-
when
yes.
you're not able to effect service.
Right.
Well,
Did
we
the
were
witness
trying here till
come in?
this morning to still effectuate service, so we're checking our records.
I'm sorry, hold on one second.
I didn't want to interrupt.
Are you a witness?
Is that here? Yes, Camille, I'm sorry.
That is one
But
of
I don't know
those.
if I'm supposed to be in here.
Okay, so we do have a, order basically by the board that any witnesses testifying in this matter will need to be sequestered. So unfortunately, you can do one of two things. You can, well, pretty much one of one thing. It's basically go in that room back there, but you'll have to leave your cell phone out here because these matters are being live streamed on Facebook, YouTube, and everything else like that. So, there's a concern as to, somebody hearing somebody else's testimony and then adjusting their testimony based upon that, so.
Or I can just wait up there.
So, well, we do have a witness room basically that
But
we
I'm
set
not
up
gonna-
back there.
I don't know.
There's two witnesses.
Yeah, there's already
already
two
in that
witnesses in
room.
there.
There's a desk here where you can leave your cell phone.
Yeah, I don't want to leave my cell phone, so I'll go.
Or you
through
can
the
give
car.
it to the attorney.
Well, the problem is, well, we do want the self, or the concern is that somebody's gonna go, like, you're gonna go on you, and, maybe not you per se, but somebody's gonna go on YouTube, somebody's gonna go on Facebook Live and view these proceedings, and again, that could impact their testimony. So I guess, the board, she doesn't appear to want to put her cell phone there, so does the board want to issue an admonishment that
No,
she
I'll put it in the car
cannot
because I don't know.
view Facebook or anything else related to these
I
proceedings?
think we should have the rules consistent for all of the witnesses.
I understand, I'm gonna go put it somewhere. I'm not
Okay.
gonna.
Like in your car or something?
Yes.
Okay, and then when you come back in, we'll have you go sit in that room.
Thank you.
Thank you. My apologies, parties, you can continue. Thank you for letting me know that the witness was back there.
The other point is, they keep saying, well, we were under the gun to disclose witnesses and evidentiary, and our evidence, on time. First of all, and so what the problem is, because the objectors, who burden it is, but beyond that, just disclosure of witnesses, which they did, doesn't preclude them from continuing to try to effectuate service, so it's irrelevant in that regard. And the entire argument that 237, under 237, you can have an adverse inference or finding, that's for a timely issue. Rule 237 notice. That the problem here is this was untimely, and not done in accordance with this board's rules.
Is the board ready to deliberate and rule on this request?
Yes.
Okay, so, the parties have presented argument as it relates to the objector's request for Rule 237 to be issued to the candidate. They did send that over, late Wednesday, I think the time is about 9 p.m. And we now obviously have an objection to that. That was also filed yesterday, so the board has begun some deliberations. Does the board have any other thoughts or questions?
Well, my question, and this Mr. Mullen, I think, attempted to answer, but the answer wasn't clear as to why on the 24th when we were here, you didn't specifically request 237 for a party that is that important to your case and start the process of serving that instead of waiting until later in the week.
I think the real reason is we wanted to avoid the objection, and we didn't you know, Mr. Residency raised an objection to the ability to do that at all, and we wanted to avoid that objection, and that's why we didn't do it at that time.
Thank you. Be good.
Does the board have any questions of me?
Do you have an opinion or advice?
I mean, I would say that as a general rule, in my practice, in my experience practicing before the Cook County Officers Electoral Board, as well as the Chicago Board of Elections, I have issued Rule 237s. And in some cases, they have been complied with, in some cases, they haven't been complied with. And I do think a lot of it, though, has to do with the timing. And those were situations in which I didn't issue a subpoena, I issued the 237 in lieu of the subpoena. So, personally, I think that, you know, that there was a subpoena issued. If at the time they had any inkling that they were gonna potentially have issues with service, they could have argued the 237 issue. And there were some arguments going back and forth on whether the board had the authority to do the 237, but no ruling on that was requested at that time of this board on the 24th. So I do have a concern that less than 48 hours before the hearing, you know, basically about 36 hours before the hearing, to have something sent to a party to say, here, get these, you know, 10, 15 things together, and by the way, you have to be here. You know, I feel that either after the hearing on the 24th, there should have been a request, an official request, and a request for a ruling from the board as to whether it was gonna issue or allow the issuance of 237. Because it's not clear under our rules that you guys will allow 237s. It is a discretionary thing. So at that time, they should have been asking you, as the board, can you please exercise your discretion and give us the allowance to file 237s? And that was not done. So I do have a concern related to, you know, something coming in of this nature 36 hours before the hearing. Now, I completely understand that we are under a very expedited schedule, but that's the nature of this practice. We kind of all know this coming into this. I mean, I don't think any of us has gotten a good night's sleep in 3 months, except maybe on the weekends. When we don't have hearings, but then we sometimes have hearings on the weekends. But anyways, I just bring all that up to say, you know, a lot of us are working around the clock on these cases. And while it is sometimes difficult to get everything done and, you know, see everything, have that foresight to see what's gonna happen, you gotta try your best to have that foresight. I think the better course of action would have been for Objectors Council to ask for the 237 on the 24th, argue that issue, then the board could have said, yes, you can file 237, or no, you can't. You're stuck with the subpoena. The board could have made a decision one way or the other. This feels like an attempt to, well, we didn't get it this way, so let's try that. And if they wanted to do both, they could have done both, but I feel like they should have made the request and asked the board to rule on that request last Friday when we were here. That's my personal opinion.
The issue for me is one of the timing, and that is the concern, and I understand the objector's point of suggestion of an attempt to hide the ball, which I disagree with. It's a matter of timing, and because of the timing of when the 237 was attempted to be served, that was too late. It should have been raised soon, so I moved to grant the objection and quash the 237.
Do we have a second on that motion?
I'll second.
Any further discussion, or would the board like me to call the
Well,
roll?
what bothers me about it though is I'd feel better if I saw the proof that Senator Harris was trying to be served the subpoena and failed, because when I sit on the city of Chicago, I like, as a hearing officer, we always see the failure, the process server couldn't serve or whatever isn't done. We see that, and then we can order it again or decide where to go from there. So I have a hard time with this, because if he's not here, and of course for me it would have been great to look Senator Harris in the eye and ask him questions. I wish he was here. But if he's not here only because he avoided the service of the subpoena, then I don't think that's an out we should give him. But I don't see any proof of these multiple service of the subpoena and the failure to find him and where they were and what time they were and what day they were. So I have no record before me of that.
And as I said, we did intend to have the process over here today to testify about that. He just alerted us this morning that he produced.
Well, I did ask that for that.
I think when I've been involved as a hearing officer, we've always, excuse me, made the arrangements. It was always given at the end of the initial hearing, whether the candidate or the objector would be there. So there wasn't any issue, and we were on a faster schedule. In some respects, than what has been done.
Yes.
You know, and so the problem for candidate is we can make assumptions also based on what's happening. You know, so it can go both ways. So in one respect, I think it's too late. That should have been arranged initially to require the candidate, whether in person or by Zoom, we now have that capability. And the fact that he's not here, there's an assumption that could be raised as to what that means. And he's not able to answer questions, so.
Okay, is the board done with its deliberations? Would like to?
And also, I'd just like to clarify also that the expedited schedule is really not based on one of our members' time away from the hearings, but on the early ballots being sent out, the schedule.
Oh, I
We're
thought someone
expedited
was
because of
unavailable
the
on next
election.
week.
Pardon me?
I thought someone was unavailable on
Yeah,
next week.
member Asfalt is unavailable
But we can
next
meet
week, so
with the
yeah, the
two
board
of
can
us.
still,
We have a quorum, it's just the we are, you know, already weeks into this hearing. So for the election schedule, we need to finish.
okay, so is the board ready to rule then?
I'd like a repeat of what we're ruling on.
Okay, all right, I will read back the motion. The motion made by member Swanson was to move to grant the objection to quash the 237 request filed by Objectors Council. And that motion was seconded by you, member Asfalt. So is the board ready for me to call the roll?
Yes.
Okay. All right, Chair Raymond?
No.
So just to be clear, so you're voting no against the granting of the motion to quash the
Correct.
237? So you would allow the 237? Okay, I just wanted to make sure that it was clear, because I was, some of the things you said, I wasn't sure. So, okay, so you're saying no, all right, and member Swanson?
Yes.
And member Asfalt?
Yes.
Okay, motion carries 2-1. The Rule 237 is quashed. Okay, so the next item I believe we have is I'll just let the the candidates council, they had two other preliminary motions that they were presenting. Which one would you like to proceed with next, candidates council?
The motion to strike submission of all hearsay unmarked exhibits. We tendered a hard copy to the board. It is a very short motion in answer to voluminous documents that I don't know that the board has seen them yet, but they are unmarked. There's no exhibit numbers on them. They're uncategorized. They violate the rules of evidence. They violate the rules of this electoral board. They violate the rules of decency to bring a man's children and wife into these proceedings. They are a violation of due process of law, being dumped on us, and I'm saying the word dump, in a document dump, without any references to them at all. Our staff was up very late, running them out, those that we could run out, some we couldn't run out, and categorizing them in some fashion I have to tell you, it is the biggest document dump. It's unmarked, uncategorized, and should not be let in, as well as hearsay. They're meetings.
Let's short, I understand your point. What specific exhibits are you complaining about? I know there are some that are, none of them is marked.
None are marked.
I understand that. There are some, if a witness is here, they can lay a foundation for, and they could be appropriately admitted.
Yes, sir.
There are others, like some of the videos, I have serious reservations about some of the others. So which specific ones are you objecting to?
It's hard to say which ones, because none of them were marked. We were having that problem, and it certainly all the videos of Senator Harris's children and wife, and the pictures that are just pictures. If they have witnesses who can identify, that's a different story. They can show them, as you know, Judge, they can show them the document, mark the document, and get it into evidence. And how about the newspaper articles and the sports clips and that? Really? I mean, even though this is an electoral board and an administrative agency, we still have to deal in some semblance of law, in some semblance of order. We have to be able to defend our candidate. I mean, he has rights too, not just the objector, the candidate has rights also. So it is, I don't ever remember having to file something like this, because I've never seen a document dump that is, you can't identify.
Objectors respond?
Sure, I have never marked in 20 years of litigating until I get the witness on the stand what my exhibits are going to be. Mark number one so far. It depends on who the witnesses are, what order they are in, who shows up. There's no no requirement that we number the exhibits, and there is not a huge number of them. With respect to the photographs, those are all, they come from Napoleon Harris's Instagram page, which is his Senate Instagram page, where he has about 4,000 Instagram followers, and these are all public pictures that he has posted on his Instagram page, or his wife has posted on her Instagram page, where she has 1,500 followers. So all of these documents are in the public domain. They're all documents that show Mr. Harris or most of them show Mr. Harris at the house in Flossmoor that he says he doesn't live at. So now, I understand they may have questions about authentication, hearsay, and we'll get into that when we, pull the witnesses and try to introduce them. But to say outright that they're objectionable is premature.
They've alleged we violated, quote, rules of evidence and the board's own rules, but there's nothing in the rules of evidence that require us to disclose evidence itemized and labeled and categorized with exhibits. Neither did the board's rules do that. The purpose of, excuse me, us having to give the evidence ahead of time is to put them on notice of what documents that we have. We don't know what we're planning to introduce. Not to set forth in chronological order the evidence and what it means and what the significance is and everything like that. So yes, we've given them a lot of documents because we have a lot of evidence.
I am ready to rule, but in fairness to Mr. Olson, as he's the ruler, I'll give him a brief time to reply.
I'll stand in my comments, Judge. I think I made my points. We have a right to defend ourselves. We have some knowledge of, I don't have any knowledge of TikTok, Instagram, and very limited Facebook, quite frankly. So I'd like an identification of what the heck I'm looking at so I can defend my client. That's it.
I understand your point. I make a motion that the motion to have strike this evidence at this time be denied. With that in mind, it does not mean that any of it will be ultimately admissible.
Second.
Okay, so we have a motion by member Swanson to deny the motion to strike, let me just find the exact title of the motion. To deny the motion to strike the submission of all hearsay unmarked documents, and that motion was seconded by Chair Raymond. Is the board ready for me to call the roll?
Just, for discussion purposes, if we granted this motion, I wouldn't know which documents or pictures or videos were stricken. So I can't grant it, but I agree from the preview I saw that there are, pictures we wouldn't allow because we already discussed the date range, which some of those pictures seem totally inapplicable to, and the children would not be involved in this hearing. So when we go through one by one, I'm sure many of Attorney Ogilson's exhibits that he wants stricken will be stricken, but to just the blanket say yes, I don't know what would be stricken.
And if I may respond very briefly to that, the candidate has submitted an affidavit or proffered an affidavit that says he has lived at that address
I
since
haven't
2014.
seen any such affidavit, so
Okay.
I don't want to discuss
Okay.
that at this time, till such time as I see it.
I've seen it, but I don't think it's introduced in the record yet.
Yeah, and I would actually, caution the board, I mean, you guys are in deliberations, if we wanna expedite things, we've gotta stop, no offense to both councils, and I'm telling both councils, but we've gotta stop, unless the board is asking a question of the councils, I think that, we need to keep these things moving along.
We're ready to
I'm ready to
vote.
vote.
Okay.
I just want to clarify it, because we're talking about allowing it all in subject to kicking it up. So in other words, if they start presenting something that we deem clearly hearsay, we're not accepting.
It'll be subject to the rulings of the board as to whether the document itself is admissible. Whether the proper foundation has been established and whether it's admissible under the rules of evidence generally and under this board's own rules.
Denying this motion, that does not admit any of them into evidence for all
Correct.
consideration.
Correct.
It comes on a case-by-case basis.
Correct.
I'm ready to vote.
I'm ready to go.
Okay, Chair Raymond,
Yes.
Member Swanson,
Yes.
Member Osfeld.
Yes.
Motion carries. The motion to quash, or to strike submission of all hearsay unmarked exhibits is denied. The next item we have from the candidates council is a motion to quash subpoenas served by the objectors.
Yes, thank you. Again, Ross, Secretary, if the candidate, I'll be very brief. This would only come into play if the objectors try to force these unserved subpoenas, at least as with the filing of this, we gave examples of their attempted servicement on some of these witnesses apparently, and it is not proper service under the rules, and therefore, it really is just, if they were to try to seek enforcement, judicial enforcement, by this board of these subpoenas that have been served, requested that.
My view,
So do you want to enter and continue this?
Your motion is at this point premature. We'll deal with it on a case-by-case basis.
We're thinking the same thing, Member Swanson.
Thank you.
The last matter I have relates to the relevant time period. And so there's been a lot of dates, and this board allowed, their subpoenas to go back to November 1 of 2023. It's a 1-year durational, under 60 ILCS 1/55-5, and pursuant to the case of Schuman versus Fleming, 261 Ill App 3rd, 1062. It's 1 year from the date that the candidate signed his statement of candidacy. And the statement of candidacy is going to control that time period.
What date range are you saying we should be?
It would be from it should be in the record, his nomination paper should be in the record with statement of candidacy. The caucus that occurred happened in December. So it would range sometime from December of 2024 to December of 2024.
We had, as I recall, we had extensive discussion as to the time frame. The time frame that was entered into was discussed and was agreed upon by all council. So this is not the time to bring that up. It was already thoroughly decided and reviewed.
That was with regard to subpoenas to get documents.
I think what Mr. Residency is arguing is when the 1 year time frame begins and when it ends. So I do note for the record that Mr. Napoleon Harris did sign his statement of candidacy on 12/5/24. And I can also state that as a practicing attorney in municipal, township, and other areas of public law that deal with residency requirements and deal with eligibility requirements, it's always been my opinion that it is, you know, generally the 1 year from the date of signature, but you really gotta look at actually the 1 year from the date that they take office. Because, you know, there's been some arguments in prior cases about, you know, that the clock starts ticking backwards from the 1 year of the date of the election. But I've always honestly looked at it as 1 year from the date that they take office, because that's when you actually become, you actually enter into that position.
So the time frame would be considered, when they take office, would be when the first Monday early in May?
It's actually under the statute, it's the third Monday.
Third Monday in May?
Yeah, so that would be May 19th.
So what you're suggesting then is any testimony to be relevant has got to deal with the time frame of May 19th, 2023, or 2024.
To 2020, yeah, correct,
To May
2024.
19th of 2025. That's the only relevant time period?
That's how I view the law. That's my,
But what range did we originally do?
we had given them from 11/1/23 to basically the present, and I think that was, you know, just to allow them to capture everything that they thought that they could capture without going back too far. Well, it wasn't to the present, it was like 12, hold on, I have it here, just give me a moment. We definitely did, you are correct, but it was close to the present, it was sometime, I think it was till 12/5 actually. Because I think it corresponded with the date of the submission and signature of the nomination petitions.
I thought it was about a week later in December.
December 16th, okay.
So,
Thank you, Nana.
3 years, November 1st, 23 to 12/16/24.
Yes, but that was just solely for for the subpoenas. That was not for what the residency time frame was. But I think that both parties should be allowed to argue what they believe when the residency starts. But I was just addressing the arguments made by Mr. Residency. But both parties, I mean, can certainly make their arguments and may disagree with my assessment on when residency.
Briefly, Counsel, you're looking like you wanted to say something.
Well, the statement of candidacy is a sworn statement that he's qualified to hold office as of that date. As of that date, he would have had to satisfy the 1 year residency requirement, not some future date in the future. And some of the information from that window might be, even documents they've produced to us predate that time
I think
period.
that's why Mr. Residency, when making an assumption here, mentioned the statement of candidacy date, which is December 5.
Right, and
So
I
then
believe the case that he
purposes-
cited is.
For purposes of residency then, I will make the motion that the applicable time period for evidence to be submitted is December 5, 2023 through December 5, 2024.
But you're saying something different.
I mean, that's my opinion, my read on the law. You guys are the board, you guys make your decision. I've always, I understand the argument, and it's a SINCUS-based argument that basically says that when you sign and file your statement of candidacy, you're saying you will be eligible, or that you are eligible at that time. But I know that there's been some recent cases, in fact, I wanna say it was like 2 years ago, I believe, there was a case. It was heard in the circuit court, I don't recall, I might have a copy of the ruling somewhere, I'd have to try and track it down. But it was heard in the circuit court, it involved a woman named Jocelyn King in the village of Dalton. There was a residency objection filed against her. And in that case, one of the things that was at issue was when was she required to become a resident? And if I recall correctly, at oral argument, the judge, and I want to say it might have been Ward Kirby, but again, I'd have to relook at my notes. The judge had essentially said that it was her opinion that residency ran from, I believe it was either the date of the election or the date that they took office, but that residency didn't per se run from the date that you signed your statement of candidacy. But I would say that that's an argument for the parties to make. So I think you've ruled on what you believe the relevant dates are. So I think the parties need to make their arguments as to what they believe the case law shows as to when residency is.
I think they've just done that. So let's vote.
Okay,
Oh, is there a second for the motion?
yes, I was just gonna ask, do we have a second on the motion?
What is the motion?
The motion was made by member Swanson to limit the relevant dates for evidence related to residency from 12/5/23 to 12/5/24. Is that a fair statement of your motion, member Swanson?
Yes.
And which council agree with that and which disagree?
We agree with that.
Mr. Residency mentioned that time frame in his presentation.
So everybody's in agreement? Okay,
Okay, so we've got a motion, do we have a second?
I'll second.
Okay, is the board ready for me to call the roll?
Yes,
Okay, Chair Raymond,
yes,
member Swanson,
Yes.
member Osfeld,
yes.
motion carries 3-0. Okay, so I think we've dealt with all the preliminary matters. Are there any other preliminary
Yes,
matters?
can we please request that one of our witnesses be released, because he was merely here on the subpoena issue, if there was an issue about how the subpoenas were served. So
Okay.
if there's not an issue, if that's deferred, on 20 minutes notice, I can get him back, but instead of leaving him there without his phone, I'd like to release Mr. Suffolk.
What was he, I guess, what were you intending to call him to testify?
They were saying that subpoenas were delivered without checks. He has knowledge about that, so
Is that an issue that he's gonna be called for?
if necessary, yes.
Well, if he's potentially gonna be called, it's a state sequester. If you're saying that's not an issue where his testimony is not gonna be required by either party, as far as I'm concerned, he can go. So, that's the question, just goes to you all, council.
They just, what was the result of their motion? It seemed like they were not, it was deferred, so we're just continuing him indefinitely in case they bring it back.
Can you explain again what issue he addresses?
Exactly, what is the precise issue?
They filed a motion saying that people were served with subpoenas that did not have checks with them. He delivered checks to them, so he has knowledge of them having the check. So if they're going to make an issue of that, then he's here to counter that particular issue. Yeah, it has nothing to do with the merits of the case or anything that would be streaming on the video. That's why I don't think he would, if he went and listened to everybody's testimony about the Colleen Harris's residence, it's not going to impact his testimony about who he served with checks or subpoenas.
Which of your motions raised that?
The very last one.
Name it.
The motion to quash the subpoenas.
Oh.
Somehow it seems that if this is gonna be an issue, let's just have him get sworn, testify that he gave a check to everybody and move it on.
I kind of was thinking the same thing. We would testify for what, all about 5 minutes?
Depends which, I don't know which subpoenas they're arguing about, so it depends.
The ones where people weren't given a check until yesterday, after the subpoena was delivered, or this morning. They went back and covered their tracks and started giving checks out after they delivered the subpoenas.
So is that a moot issue that's dropped?
No. Subpoenas were delivered,
How many subpoenas are we talking about?
We have no idea.
How many subpoenas? 2? So why don't you just call him to testify to the 2 subpoenas? And let's just get him out.
Break him out. Break him out.
You can sit there.
Okay, Can you raise your right hand and be sworn by the court reporter?
Do you swear or affirm that the testimony that you're about to give will be the whole truth and nothing but the truth?
I do.
Will you please state your name?
Richard Seppet, S-E-P-U-T.
Directing your attention to this morning prior to 11:30, did you have occasion to visit the home of Nina Graham at 17333 Wausau Court in South Holland, Illinois?
I did.
At that time, did you deliver a money order in the amount of $25?
Objection leading.
What, if anything, happened at that time when you went to that residence? Oh, got a question for you, sir.
I went to that address, I knocked on the door, an elderly lady came to the door, I asked her, if she was Nina, and she said no, that she was the mother, and I said, well, can you please give this check to her, and she said, I'll call her, let her know you dropped it off.
And then, did you drop off a money order?
I did,
What was the amount?
$25.
Also, this morning prior to 11:30, did you have the occasion to visit the home of Colonel Washington at 14638 Gibbons in Harvey?
I did.
What happened when you arrived at that location?
I arrived at that location, I knocked on the door, and then I rang the doorbell. Nobody answered, and there was a basket on the door, and I did see the court order in that basket.
When you say court order, what was it, the subpoena or?
The subpoena. It was in a basket hanging on the door.
And what did you do at that time?
I left at that time because nobody answered the door. Then I talked to you, and you said go back there and take a picture of the subpoena and the check.
Did you deliver the check to that location?
I did.
The money order, what was the amount of that?
$25.
Did you take a picture of it?
I did.
Do you have that?
I do, my phone.
Permission for witness to look through his phone?
So granted. There's only one here.
That's me. Thank you.
Can you please pull up whatever picture you took?
Yes,
this
ma'am.
morning? Can you show those pros and cons, please?
And to the board.
Can you-
Oh,
Can you please identify what that picture is?
the picture is the subpoena and the check that I was dropping off.
And that was at the,
Gibbons Court.
let's see, it was 14638 Gibbons Court?
Yes, ma'am.
And does that picture accurately reflect how it looked at the time you took the picture?
Yes.
I have no further questions.
Sir, with regard to the check, let's start with Mr. Washington. When did you serve the subpoena?
May I look at my phone, I can tell you that.
Do you recall when you served the subpoena?
It was around 10:30-ish
What day?
today.
Okay, so you
Not the
served,
subpoena, sir, I only dropped off the check.
okay, so you never served a subpoena on Mr. Washington, correct?
No, yes, that's correct.
Okay, and with regard to the check, you brought a check to an address on Gibbons for Mr. Washington, correct?
Correct.
And you didn't serve the check on anyone, you put it in a basket, correct?
Correct.
And with regard to Nina Graham, did you serve Nina Graham with a subpoena this morning?
I did.
And you just,
I did not hear the answer.
I did not.
I did not, okay, thank you.
and so we're clear here, when you went to Miss Graham's home, you spoke to a mother and handed her a check,
Yes, sir.
and that's all you did, correct?
Yes, sir.
I have nothing further.
I have nothing further. I would request the ability to get a copy of the photo off the phone, printed up and submit that as an amendment.
Any objection?
I have no objection, is it gonna be marked?
I was just gonna ask the exact same thing. Objectors, are you guys marking that exhibit? Objectors exhibit 1, objectors exhibit A, how are you?
Sure, we'll do it, petition plaintiff's exhibit 1.
Can you send me that and I will arrange to have a copy for you of that?
Yes, ma'am.
And make further questions, so.
Does the board have any questions of the witness?
No.
Okay. All right, no plans to recall him?
Not at this point.
Okay, all right, you are excused.
Thank you.
You can keep yourself home.
Thank you.
Okay, so the board just heard some testimony as it relates to the subpoena issue. But that issue I think is somewhat of a deferred issue. So I think that the board can just take that testimony in, and now we can move forward with the objector continuing on to present their case in chief, unless the board disagrees.
No, I agree. I agree.
All right, objectors counsel, you may proceed.
We'll call, Christopher Clark.
You want him there?
And real quick before we, are you able to hear everything?
For
Or
the
do you
most
need,
part.
okay.
As long as they don't drop their voice, cause I can't see their lips.
Right.
Okay, would it be more comfortable if we move the chair like kind of right next to you?
I have no problem.
Okay, Mr. Clark, would you mind? Yeah, we could possibly change that microphone. Maybe if you just want to turn your chair.
You want me to, where you want me to?
Just tell us what you do. You'll hear your voice.
I mean, yeah, I'm pretty sure everybody in the room can hear it.
Just tell
Let
them.
me see, let me put the chair back here. All right.
Yes. Just want to make sure the court reporter can hear everything and everything's accurate.
For the witnesses' time and everything, please go.
I'd like to stay.
I have no problem with this.
Please go with this witness.
Sure. Have you sworn him in? I didn't.
Not yet.
Go right ahead,
Raise
please.
your right hand. Do you swear or affirm that the testimony that you're about to give will be the whole truth and nothing but the truth?
Yes, I do.
Okay, would you state your name for the record, please?
Christopher J. Clark.
And the court reporter just swore you in, and even though this is a more informal setting than a courtroom, you're under the same obligation and penalty of perjury to tell the truth. Do you understand that?
Of course.
Okay. And where do you reside?
My address or?
City you live in?
Harvey, the little one.
And are you an elected official in Harvey?
Yes, I am.
And what is your title?
I'm the mayor of the city of Harvey.
And how long have you been the mayor of the city of Harvey?
5 years now. I think I'm maybe in my 6th year, something like that.
Okay. And how long, over the course of your life, have you lived in the city of Harvey, the village of Harvey?
My entire city, it's a city.
City.
And my entire life, 55 years.
And prior to being mayor, what type of work did you do?
I'm an attorney by trade.
Okay, and do you have experience in any particular areas of law or?
It's general, but most of my cases range from business, family, and some municipal.
Okay. And so, other than practicing law, were you a real estate agent also?
Yes,
And when was that?
that was between, I think it was 2004 and 2006, I believe that it was.
And where did you do that work?
Meriden Warner in Orland Park.
Okay. And did you become familiar with the various, what municipalities did you become familiar with the real estate in?
Objection relevant.
Yeah, Madam Chair, we have no question for relevance. You can either ask the board for ruling yourself, you can ask the objectors counsel, what is the relevance of the question to do with objection for relevance?
What is the relevance?
We're gonna talk about the difference between Flossmoor and Harvey, just establishing some background for that.
I mean, I think the board can take judicial notice that they're two different municipalities. I mean, I don't understand what
What, well, not that they're two different municipalities, but that they have different characteristics.
I'll let Eric get us to something.
What does that have to do with this case?
We're talking about right now an incumbent senator who lives in Flossmoor, who is purporting that he either lives or wants to live in the city of Harvey. And we believe that once Mayor Clark describes the similarities between the communities, that raises a plausible inference that perhaps that isn't accurate. So we think we'd like to have on the record evidence regarding both of the natures of both the communities.
Make a motion to overrule the objection.
Second.
All in favor?
Aye.
Any opposed? Motion carries. Okay, you may continue on with your question.
Would you repeat the question for me, please?
Can you read that back, please?
And did you become familiar with the various, what types of real estate, sorry, did you become familiar with real estate? Excuse me. What municipalities did you become familiar with real estate in?
No problem. Primarily, of course, Orland Park, because that's where I was. Also, Olympia Fields, University Park, Flossmoor Homewood, and Harvey.
Okay, great. So do you know Napoleon Harris?
Yes.
And when did you first get introduced to Napoleon Harris?
Somewhere between, I want to say, 2012, 13, somewhere in that range.
And how were you introduced to Napoleon Harris?
I first met him at Coleman's Printing. That's where we first met. Printer.
Hey, Mr. Moore, how you doing?
147, but I forget exactly where. I think it was in Thornton or something.
At some time, did you come to learn that Mr. Harris was running for elected office?
Yes.
And when did you learn that?
Around that same time. It was after we first met.
Okay, and when, what office did you understand him to be running for?
Senate.
And do you remember the district that he was running in?
It's the 15th district.
I'm going to show you what we marked this plan as Exhibit 2.
I have an objection to this exhibit. This is from 2012. And the time frame we discussed, and this is why we had to disclose Michael Dorff, because we knew they were going to go down this path of what occurs with redistricting when there's the decennial census.
Well, first of all, we have a statement of what?
We have a statement of what this document is. I mean, I don't have a copy. And I did, for the record, I did ask that the parties not only bring copies for the board, but as well as us, just because of the pure volume of documents that were requested. So for the record, I do show that they appear to be nomination petitions from 2011.
What's the relevance?
The relevance is that Mr. Clark helped notarize these, and it was how he first learned about where Napoleon Harris was living at that time.
So what?
Well, it's relevant with respect to the affidavit that I understand you have not seen, but it is to counter and attack the credibility of that affidavit.
Does the affidavit refer to 2011?
It refers to him living in Flossmoor until 2014. And so in 2012, he's swearing under oath that he lived in Harvey, when in the affidavit that he submitted.
Characterization is not true.
The document says Flossmoor.
Yeah, look at the document.
So the petitions are in conformance with the affidavit that's not before us? Is that correct? I move we sustain the objection.
Okay, so we have a motion to sustain the objection as it relates to the document, that purports to be, plaintiff's exhibit 2. And as stated earlier, these are the nomination papers, from 2011, from December 2011. Do we have a second on that?
Restate the objection.
Well, the objection was to relevance, correct?
Right.
I'll second.
One question I'm unclear on. The second page, statement of candidacy, shows references living on Dunford Street in Flossmoor. At that time, which was
2011.
December 3rd of 2011. And the motion is to sustain the objection.
Okay, I will, call the roll. We have, Chair Raymond,
Yes.
Member Swanson,
Yes.
Member Osfeld.
Yes.
Okay, so, plaintiff's exhibit 2 is not admitted.
I don't think we moved for today, but.
I'm sorry, it's, I'm sorry, the objection is to the relevancy.
Yes, was to the question, right?
Yes.
I thought the objection was to the document.
I didn't-
Okay, I apologize. The objection was to the question, so that has been sustained, so you may keep going forward.
Okay, so you testified you were currently the mayor and the city of Harvey, is that correct?
Yes.
And can you describe to the board what the city of Harvey is like to live in?
Objection, relevance.
And, I mean, we discussed this before, I mean,
I would sustain the objection as to elements and form of the question. I'd sustain it as to the form of the question.
Talking about the block.
Second?
Ask a better question.
Okay, all in favor?
Aye.
Aye.
Okay, rephrase the question,
Can we,
please.
Sure.
can we shorten this by taking judicial notice that there is a nicer house in a nicer area in Flossmoor than the townhome in Harvey? Is that what you're trying to establish?
that's part of it, as well as, you know, what it's, the difference between living in, you know, a country club development and living in a, you know, in Harvey, in this neighborhood.
That's
Are
not
we-
a proper subdivision.
Yeah.
No, well, you're the judge. Okay.
Okay.
All right, but you can shorten this if you could, because I think
Okay,
we
I
all know
understand,
this.
I understand. So, can you describe the crime rate, in Harvey for the past?
Objection.
Move to sustain the objection.
Second?
All in favor?
Aye.
So, the, documents that, about this objection indicate that you, were the person that personally filed that objection, is that correct?
Yes,
Okay. And you are also a candidate for the office of Thornton Township Supervisor, correct?
that is correct.
Okay, so you would, you know, obviously benefit from this objection being sustained, correct?
It depends on your perspective.
And what is your perspective?
I'm here to help.
Okay. So, prior to filing the objection, did you review the objection?
Yes,
Okay, and why, did you assist in filing this objection?
because from everything that I knew of, it was true.
Okay, and when you say it was true, what are you basing that on?
My knowledge of Senator Harris, over the years, my knowledge of where he lives, at least from my perspective, my knowledge of the its home in Harvey, Illinois. My review of what I had seen on several occasions from Facebook posts and things in his, you call it, Illinois State Board of Election filings and things of that nature. Driving through Entree and around that area, you know, on occasions, not regularly, but on occasions, and haven't seen, you know, either him or his vehicle, you know, in the area where the house is located. A variety of things have given me, you know, have led me to that conclusion.
Okay, is there anything else that you didn't mention? You said a variety of things. I just want to make sure we get everything that you can think of on the record.
Well, going by knowing that he doesn't live at the Harvey house, I've been by the Harvey house on several occasions over the past 5 years. It's my usual routine to drive in and around the city, you know, to take note of what's going on in the city. You know, homes that are there, homes that are lived in, homes that are abandoned, homes that are dilapidated, homes that need repair, streets that need repair, making those observations. So I would say probably I've been by that home more than the home in Flossmoor, at least 50 to 75 times.
Okay, and have you ever observed Mr. Harris at the Gibbons address any of those 50 to 70 times that you've gone by? Do you know Jerlene Harris?
Yes.
And how do you know her?
Well, she's a Harvey resident.
Okay, and do you have any type of relation? I mean, do you have a work relationship with her, or how do you know her?
Well, I don't have a work relationship with her now, but I've known her like many other people throughout the city for quite some time.
Okay, and you understand that she's one of the objectors in this case?
Yes.
Okay, and did you have any conversations with Ms. Harris prior to this objection being filed?
Yes.
And what information did you relay to Ms. Harris regarding this objection?
Objection, hearsay.
Overruled. But he said that somebody is not hearsay.
Do I have a second?
Second.
All in favor?
Aye.
Aye.
Motion carries. Objection overruled in the answer.
I shared with her the same information that I've just shared with this tribunal at this particular point in time.
Okay. And you mentioned that you follow Napoleon Harris on social media, is that correct?
No.
Oh, I'm sorry.
I did not say I followed him, I said I have viewed.
And what have you viewed?
Posts that, you know, have been made on his Facebook page. Posts that, you know, when they link or share to his spouse's Facebook page. That's what I'm talking about. The following is a little bit different than just viewing. That's why I made the correction.
And so you are familiar with the, how the house at 14633 Gibbons looks?
Yes.
And are you familiar with, does it have a fireplace, do you know?
Objection. There's no foundation if he's been in the house.
Vote to sustain.
Second.
All in favor?
Aye.
Aye.
Objection sustained.
Have you observed the chimney on the house?
Yes.
Okay. And, so we were talking about your, review, your viewing of Mr. Harris's social media. Have you ever seen, a photograph of Mr. Harris, at the 14633 Gibbons, address in Harvey on his social media?
No.
Have you ever seen photos of the Flossmoor residence on his social media?
Yes.
questions?
I understand council agreed to waive scope, so this can be considered not just cross-examination, but direct examination for the candidate's case.
That is correct. I'm assuming that Mr. Clark will not be recalled if we waive the scope.
That's correct. Mr. Clark, so, Mayor Clark, so I'm clear here, and everyone else is clear. You are seeking the office of Township Supervisor in the April 1, 2025 election, correct?
That is correct.
And your opponent is Napoleon Harris, correct?
I have several opponents, but he is one of them.
And you are here testifying, as you said, I want to help out, right? You're here to help, right?
That was in reference to being the supervisor of the township.
But you're here to help out and offer testimony in an effort to have Mr. Harris knocked off the ballot, correct?
Sir?
Is that correct, sir?
No.
You're here to provide testimony on behalf of an objection that you prepared or were involved in preparing, correct?
No.
Well, with regard to the lawyers that are representing you, is it not true that Carrie Lynn Carefrafter represents the city of Harvey?
The lawyers aren't representing me.
Does Carrie Lynn Carefrafter represent the city of Harvey? Does Carrie Lynn represent you?
No.
Does she represent the city of Harvey?
Yes.
And who is paying the lawyers on behalf of the objectors?
I'm not.
Do you know who is paying them?
No.
With regard to Jerlene Harris, you went to go tell her information, correct?
I don't recall.
Well, you just testified that you went to go tell her about what you knew, right?
Not from my
Unfortunately, that
recollection. no.
mischaracterizes his testimony.
Yes.
With regard to your testimony, what did you tell Jerlene Harris?
I told her about Senator Harris not living in Thornton Township, about living in Rossmore, not living in Harvey, and as I testified previously.
And with regard to Ms. Harris, did you ask her, hey, I need you to be an objector?
Yes.
And did you do the same thing to Michael Smith?
No.
And with regard to Jerlene Harris, do you know what she did to investigate any allegation in the objection?
No.
Now, sir, the last time you were selling real estate was in 2006, correct?
Yes.
And with regard to your investigation as to Senator Harris, did you look at his voter registration?
No.
Do you know where he's registered to vote?
Yes.
And where's he registered to vote?
In Harvey, Illinois.
And did you look at any information as to his driver's license?
No.
Did you look at any records related to his contact with Harvey, Illinois?
I'm not sure what you mean by that.
Well, does Senator Harris have contact with the city of Harvey?
I'm still not sure what you mean by that.
Does he own a business in the city of Harvey?
Yes, from my understanding,
Okay, and what's that business?
a Beggar's Pizza
And where's that Beggar's Pizza at?
in Harvey.
And in relation to the property, the Givens property, how far is the Beggar's Pizza to the townhome in Givens?
Less than a half a block from the building.
Now, sir, you testified that based on your information, you do not believe that Senator Harris lives at 14633 Gibbons Court, correct?
Yes.
I'm going to show you what's been marked as Kansas Exhibit number 12. Providing objectors counsel with a copy and copy of these minutes for the board and board's counsel. And the witness. So if you could turn to page 2 of Kansas Exhibit number 12.
Yes.
Do you recognize yourself in the photograph on that page?
Yes, I do.
And this is an official mailing from the city of Harvey, correct?
No.
Well, it says city of Harvey, does it not?
City of Harvey did not mail it.
Oh, who mailed it?
Arlo from Speed Print.
But the city of Harvey authorized it, right?
He provides the addresses.
The city of Harvey authorized this mailing, correct?
Yes.
And you have them mail this to all residents in the city of Harvey, correct?
Actually, I don't, but if you want to assume that, please go right ahead.
Well, you're the mayor of the city of Harvey, correct?
Yes.
And you make sure you want to communicate with your residents and voters in the city of Harvey, right? And you had a mailer sent to Napoleon Harris at 14633 Gibbonsport, Harvey, Illinois, correct?
No.
Well, this is a mailing from the city of Harvey, correct?
Yes.
And Napoleon Harris's name is on it, correct?
Yes.
Now, sir, you've never been inside the Harvey townhome, correct?
No.
And you've never been in the Flossmoor home, correct?
No.
Now, in addition to your employment, you're the mayor of the city of Harvey, correct?
Yes.
And you're a lawyer, correct?
Yes.
And you're also a Freedom of Information Officer for Calumet City, correct?
That is correct.
And with regard to that position, is Carrie Lynn the attorney for the city of Calumet City?
Objection, Williams.
Bias.
Of me?
I move it the overrule.
We have a second?
Second.
All in favor?
Aye.
The objection overruled, please proceed.
May I ask you a question?
I don't know.
You don't know if Carrie Lynn is the attorney for the city of Calumet City?
I'm just a FOIA officer.
Did you ever FOIA who the attorneys were for the city of Calumet City?
No, I'm not that I recall.
With regard to your knowledge is based on looking at some social media pages, correct?
Some of it, yes.
And with regard to any other investigation, did you do any other investigation related to Senator Harris's residency during the period of December 5, 2023 to December 5, 2024?
Repeat that, those dates again?
December 5, 2023 to December 5, 2024.
Yes.
And what was your investigation?
I looked at his reporting on the Illinois State Board of Election. Actually, quite a few times on that. Went by the house again, meaning the Flossmoor house. And like I said, I've been by the, what do you call it, Harvey house on several occasions.
And with regard to the 50 to 75 times you've been by, did you keep note of the dates and times you went by?
Not all of them, no.
Okay. And with regard to going by 1463 in the Harvey, and I would just call it the Harvey residence. When you went by the Harvey residence, did you ever knock on the door?
Actually, one time I did.
Okay. And was he home?
No.
And other than that, one time, when was that?
When was what?
You knocked on his door.
I don't recall the exact date.
Did you take photographs?
Yes.
You took photographs of what?
I took photographs actually of the two vehicles that were in front that were covered with tarps.
So there are two vehicles in front of the property of 1463.
That were covered with tarps, yes.
Oh, with regard to I'm going to show you what is actually objectors exhibit. I'm gonna show you objectors 15. I do not have additional copies of their exhibits. I apologize. I did not know what Mr. Clark was gonna testify on. Do you
So
recognize?
just for the record, it's marked as objectors exhibit 15.
Objectors 15. Do you recognize those photographs?
All but one.
Oh, please look it up.
I said all but one.
You recognize him? Yes.
For your question, thank you.
And then the board also need to see them.
We have copies of this also, we can get to the board.
Great, thank you.
They're taking a copy of this screenshot, and just be parting out, and they have the exact same photograph, just want to get thoughts.
Yeah.
I think this is the original that you gave us.
They have their markets 15, it's all the exhibits, all these photographs.
Okay.
So I thought they were gonna do this as a group exhibit.
Okay, so this will be marked as group, let's mark it then as objectors group exhibit 15, since it's a number of photos together.
To your channel.
That's all, Mr. Council Residency, was that 4 originals?
I believe it was on it.
Yeah, I've got a couple of them. I think so.
was this? You have two of these?
You need another.
No.
I have four.
She has four
I
sheets
have
of paper.
I have two of the same, so this thing's so much.
I have four. I have,
I apologize.
I have a property tax info, at night, lights on, front of the house, and then the garage.
And I've got three.
Yeah, they have this, we're missing something.
Yeah, so there are four pages, you agree to the same. I agree to the same. So there should be four
Oh.
photos overall, we agreed to mix them with 2 copies, so that 50 photos were the same, so 4 photos overall, sir? Yes.
We have four.
We have 4, so we're split.
Mayor Clark, I'm showing you 4 photographs that are part of objective exhibit number 15. With regard to those photographs, do any of those photographs portray a chimney on the Flossmoor property?
Yes.
And where's the chimney? Well, that's not a chimney, is it?
Well, it is to me.
That's a pipe, a vent pipe coming out of a roof, right?
Objection, you're testifying. You just said it was.
I'm at the 15705 page, sir. This is what we have. These are chimneys and we're out there.
With regard to a chimney, so when you testified before, a fireplace chimney, that's what your testimony was, that there was a chimney that they saw. You're referring to a sheet metal pipe appearing in one of the photographs of exhibit number 15, objective 15, that comes from the roof line, correct?
Chimney.
Now,
Objection to that question, he was not asked about a chimney at the Flossmoor residence, he was asked about a chimney at the Harvey house.
is there a chimney at the Harvey house?
Like, yes.
Or what type of chimney is it?
Like that chimney, what you call the pipe, I guess.
It's, in your job in real estate,
Yes.
okay, and how long were you a real estate agent?
About 2, 3, somewhere
Okay,
between.
2-3 years, and the last time you did that was in 2006, correct? Did you ever do any real estate transactions?
Yes.
Okay, and with regard to real estate transactions, is it your testimony that the pipe that you're describing as a chimney is a chimney?
Yes, exactly.
And so with regard to the Harvey residence, you've already testified you've never been in there, correct?
Correct.
And you've never been on the Flossmoor property, correct?
I already answered that, but yes. Correct.
The drive-bys that you took, did you ever take photographs of Napoleon Harris at the Flossmoor property?
No.
Have you seen Napoleon Harris at the Beggar's Pizza in Harvey?
Yes.
And he works there, correct?
He was working at the time that I saw him.
And how many times have you been to the Beggar's Pizza in Harvey?
That's too numerous to count.
And how many times have you seen Senator Harris there?
Maybe twice.
There's no dispute that he owns that restaurant, correct?
Well,
Objection, Mr. Olmert.
I'll let that go first.
We have a objection as to relevance as to whether Napoleon Harris owns the Beggar's Pizza in Harvey. How does the board want to roll?
I don't see any relevance.
With regard to the Flossmoor residence, or sorry, the Flossmoor property, your testimony is that you drove by a couple times, correct?
Yes.
And how many times did you drive by?
The line train, maybe about between 10 and 15 times.
what time period was that?
During the day.
And what time period, over years, months?
Oh, that was over years.
Any time during the time period of December 5, 2023 through December 5 of 2024?
No, I don't believe so. No.
I'm not concerned.
Any questions on redirect?
Yes, with respect to candidates exhibit 12, that has an address for Mr. Harris on it. Did you do anything to ensure that the people who received this mailer were residents of the city of Harvey?
No.
Do you happen to know what car Senator Harris drives?
I've seen it's Cadillac, black.
Okay, and is there any particular license plate that you recall seeing on the car?
Yeah. The state license plate, I forget the name of it, but it's a black SUV.
Okay, and in the times that you have gone by the Gibbons address in Harvey, have you seen that car parked there? I have no other questions.
Mr. Harris, the Harvey residence has a garage, right? Oh, sorry.
Mr. Clark.
Mr. Clark. The Harvey residence has a garage, correct?
Yes.
I'm not. Council, you're moving the addition of this exhibit 12. I will be moving, yes, to the second page.
Which is the second.
Any objection?
Well, can you say that, what is the second page?
Well, this is, he's got 12, you've got, that's 15. This,
Oh. 12.
Candidates to do 12.
Motion by the board to accept exhibit
So
12.
moved. To accept.
Second.
All in favor?
Aye.
Motion carries, exhibit 12 is admitted. Objectors, I'm sorry, candidates exhibit 12. Any further questions for this witness? None?
No further questions.
Any questions by the board for the witness?
I have a question now, because you say you often drive by Harvey, the property, and you don't see Senator Harris there. Is there a yard like a house would have that you might see him, or a grill, or is there any exterior that's his? Or is this more like I know it's a townhome, but is it more like a condo where there's not really outside property?
It's not much of outside. It has small frontage to it. It has small area, but no, not much as far as exterior.
Okay, thank you.
Any other questions by the board?
And you're not looking in the windows, right? Like you have to be outside, right?
You may want to advise them.
You complete the fifth.
I'll drop that question.
No, there's an answer to it. If you like it, the answer is no. I just found it weird that I'm a member of the bar. I'm not conducting myself in a certain way, so when Residency has certain things to say, they're kind of, I work very hard to get where I am.
I admire you for being the mayor of Harvard, yes. Thank you for taking the time to talk to us.
Thank you.
And you're, I understand you're done with this witness?
Yes.
You're excused, Mr. Clark.
Thank you. May I return the exhibits to the respective tapes?
Actually, if you could just give them to the court reporter, they will be then made part of the record.
Okay. Thank you.
Don't forget your phone.
Yes.
Was objectors,
It was
I'm sorry,
only
Ken.
12 was admitted.
okay, so are you seeking, Mr. Residency, to move the exhibits that were produced by candidate? I'm sorry, the objectors exhibit 15, I think, are you?
Not
going to
at
do
this
that?
time.
Okay.
I may do it later.
Okay, so just for the record, the only item that has been moved based upon Mr. Clark's testimony is candidates exhibit 12.
Okay. we would move to introduce, candidates exhibit 15 into evidence.
Any objection?
No objection.
Move to admit it.
Second.
All in favor?
Aye.
All right, candidates exhibit 15 is admitted, and just for the record, what I have here is not complete, I still only have 4 pages, so just if somebody before,
There was
a
a, there's,
decision?
what occurred was when they submitted their exhibits, they had 2 photographs which were identical.
Oh,
So
so
we
it is only
removed-
4 pages?
It's only 4 pages.
Okay, great, all right.
So the pictures, the 4 pages of the house are what exhibit?
Those are objectors, exhibit 15. So I'm keeping a separate list of exhibits that are being entered into evidence. And so far we have candidates exhibit 12 and object 15.
And Tiffany, also, I believe the first piece was the photo by Rick Seffett of proffering that he dropped the money order with the affidavit in the Harvey resident basket.
That's what I know is exhibit 1 that you guys.
That's objectors exhibit.
Yeah.
Correct. And then what is that document there again? And then this was the petition stuff, that was not the. Just wanna make sure I'm keeping a.
That's what I was voting for.
Yeah.
Come on, let's
Can I
get
get out our witness and get her out here? If she needs to use the restroom, she can also.
That's a
Who's
good
up
idea.
next?
Camille, so-
Oh. Here, I'll show you guys. Well, here, I'll show you guys. Well, the bathroom's that way, but we should keep it right there. Great. Sort of this tiny one to bring some sandwiches. They're not there.
Oh, what is that?
Yeah, the clerk, said she was bringing some. I just got
Thank you.
Oh, like they're breaking and taking a break.
Yeah, they are taking a break. Saying facts is how it's
Whether it's facts or not facts.
I bet y'all know how these, bro. Been working together. Just a winner. Thank you. We're gonna talk about this.
And that's what he
Really? Oh, yeah. Anybody need anything? No, don't you ask, I might have to hit you with the knee. Not you. No, what you need? You want some water or something? All right. Make sure you squeeze it hard. You know, some needle holes.
How's South Village going? How's South Village going? How's South Village going? I can treat my buddy, Mayor Burgess.
South Village is a very close second to Dalton.
I know, you know why? Who's the middle of it? Otis. Everywhere Otis would go. It's chaos.
South Village could use you. You should go back a second.
Huh?
You should go help Burgess.
Oh, I'm out. You should. I'm out. He's gonna win again. And I don't beat him. Well, two candidates, one candidate.
With regard to business service.
But I wanna know what's next.
All right, Doc.
Yeah, we got
Hey, listen, where's the YouTube camera that's supposed to be watching us?
Come on, wave, y'all. Give us a wave.
Can't hear us. You won't see me around. Right now, I'm on school. Okay. But Vice President, Thornton Township. Okay. We feel we doing something. We just
Okay.
things together.
All right. Yeah, I'm public duty. So, yeah. Urban legend.
You kind of shoot attention. Because tonight, we do a media reading downtown once in a while.
Okay.
So tonight, I got two state reps coming. It'll be real nice, lawyer, and everybody got to meet and greet, you know, get some different knowledge and views on different things. So like,
Gotcha.
yeah. So
Okay, I'll text you up.
I'll see you.
Okay.
Are we back? Are we going back? Everybody ready? Back on the record?
Anybody else need water? Everybody fine? Could I have water? Yeah. Okay. Thank you very much. Anybody want to walk? Who else? Go ahead, put it.
Up here, up here.
I got you, I got you.
All right, you got it.
Take all that. Did you want one? Sure.
Here, you can slide this one. Don't worry about it.
Another one? For Lynn? I gave you one. Okay.
Okay, are the parties ready to go back on the record? Okay. Objectors, I believe you are calling another witness?
Yes. Would you swear to this? Raise your right hand, please. Do you swear or affirm that the testimony that you're about to give will be the whole truth and nothing but the truth? Can you please state your name?
Neil Corncia Soria,
Can you spell your last name, please?
KRENCJARZ, Soria, S like Sam, ORIA.
And
I'm sorry, could you respell it? I apologize.
KRENCJARZ hyphen S like Sam, ORIA.
Got it, thank you very much.
And where are you currently employed?
City of Harvey,
And what is your position there?
supervisor in the water department,
How long have you worked for the city of Harvey?
over 37 years.
How long have you been a supervisor of the water department?
Probably about 10 years, but about 15 years.
Prior to being supervisor of the water department, what positions did you hold at the city of Harvey?
When I started, I was a cashier. I went to regular clerk, I went to accounts payable, I went to payroll, I went to supervisor of accounts and finance, and then I know in 2000 I switched to water.
And are you familiar with the water billing system in the city of Harvey?
Yes.
What are your other responsibilities as supervisor of the water department?
From the water department, I actually send out the bills, make sure the bills go out monthly, communicate with the villages, make sure the readings are coming in, several different ways we try to bring in readings.
So can you explain the process to us for how the meters get read and then generated into bills in the city of Harvey?
Yes. We have different meters, so there's some that are very old. We have ABB meters, amplimeters, and then we have census meters. The old ones that are Rockwells, we still have to visually read.
So what does that entail?
That entails us going there and actually looking at the meter and getting a reading on it. Then we have the AMCO or ABB meters, those were all installed in 2000. At least the ones that we could exchange in 2000, we did. Those were set up to get remote readings from a vehicle. We make flash drives in the office at the first of every month. The gentlemen come in, pick up the flash drive, we put different books, which we call areas, on the keys, separate flash drives. The gentlemen go out and read each book or route. They bring the keys back in and we upload the readings that they retrieve into our billing system. There are census meters that we've been installing and trying to exchange since 2019. They're smart meters, they're hooked to a tower. So on the 10th of every month, I actually communicate with census and I can bring all the census meters that are communicating with the tower into our billing system.
Are you familiar with the property at 14633 Gibbons Court?
In some way or another, I mean, I know now more familiar, but I mean, there's over 6,000 accounts, so yes, I'm pretty familiar with a lot of them.
Do you know what kind of meter is at that property?
Yes, it's an older meter, I don't know if it's ABB or AMCO, but it is located on the inside of the property, which used to, we would drive by and pick up the reading. It's not accessible for us outside.
So generally, after someone picks up a meter with the truck, what's the next part of the process?
After we pick up the readings with the trucks and bring in the census meters, we run AB reports.
What is an AB report?
These are AB reports, and they are actually all the accounts in that particular route that didn't get a reading, whether it's census or ABB meters.
So when you say AB report, what is AB?
Abnormal report, which means that it will flag any account, whether it's a negative reading, a positive reading, a high usage reading, a zero reading, anything that's abnormal to the customer's previous reading or history, it'll flag it.
Then what, if anything, do you do when you receive the abnormal reports?
Well, we prepare the AB reports in our office when we bring in the readings from the flash drives the guys go out there. We prepare them and we send them back out with the gentlemen that read meters at the pump station. And they try to obtain as many readings that are outside in the parkway as possible. We also try to contact customers either by yellow card, phone call, sometimes big yellow card saying we need access to the meter for visual inspection of the meter. But they try to get as many readings on this as possible.
So why would you need to follow up on a property that's on the AB report?
Because either we haven't received a response, we send out little yellow cards for people who have meters on the inside. They can write a reading down, drop it in the drop box, or they can call it in. We send big yellow cards saying to please call the office. I mean, we have a lot of people's meters that are not communicating, but that doesn't mean they're not working. So the meters that were installed in 2000 have what's called ERTs on them, they're electronic reads. That piece may be not responding or communicating with our system, but the meter may be working well. When those were installed, they were only foreseen to be, the battery in those only were seen to be lasting 8 years. Some have lasted 10 and some have lasted 24. It just depends on where they're located, how they're located, so. The other ones have ERTs for MXUs on them. We have some troubles with those too. Those are the communicator. Sometimes the meter will bring us over the same reading over and over, but it may not be. It may be a false reading because the communicator's not responding.
Okay. All right, I'm going to show you what was attached to the objector's petition as exhibit number 3. I have a really good
What exhibit are you using related to your experience?
This was attached to the objector's petition.
No, I understand, but are you three? Was number 3?
and we're gonna show you what I've marked is. And I can do 2 copies of the same thing. Okay. Do you recognize this document? Yes. What do you recognize this to be?
It's a history of, a water account, an address water account that has the billing dates on it, the penalty dates, the payment dates, and on the side of them, it will also have the readings and the consumption.
Is this something that's regularly generated in the course of business for the city of Harvey?
This is monthly generated. This is a history of somebody's account.
And this property is for 14633 Gibbons Court?
Correct.
What customer is this, Dennis?
Napoleon Harris.
What does the customer name indicate on it?
Either the,
Objection. Foundation.
Move to sustain this before.
Second. All in favor? Aye. Objection sustained, please restate the motion.
Okay, does the service address indicate who the customer is?
yes,
Who is the customer?
Napoleon Harris.
Now, sometimes when you generate reports, do they indicate the word vacant on them next to the customer name?
I have a few of them.
And in what instances would that occur?
The customer would notify us that they still want the water on to their convenience. They don't want the water shut off and their account finally closed. They want to continue keeping their water account open.
Now, directing your attention to the third page of this, I'd like you to just kind of explain this document, particularly the second to right line. If you look at page 3, for example, the top says S 6278, S 6164, and it goes down and it says auto below that. What's the difference between the entries that say EST and that say auto?
The ESTR.
Where are you specifically looking on page 3?
The second to right column at the top, it says EST 6278.
Okay.
And going down and further, it says auto, and it's asking what the difference is between those entries.
In the system, we coded whether it's an estimate reading, which is EST. Some are auto, which would have been picked up from the truck, in this case, driving by. There's customer readings on here, or maybe customer readings on here as well.
Okay, so can you just walk me through like the time entry, on the top of page 3, it says 6/30/23, what would that date have been? Like, why would that be indicated here?
Objection beyond the relevant time period.
Well, but right now, I just want the document explained. It's not, that is not an attempt to do residency or not, I just want to put it and explain what the document is. If you want, right, we can go through the.
Move we allow it for that purpose.
Second. All in favor?
Aye. So what would that date be?
The bill calculated on the first line,
Yes.
that would be an estimate bill based on a previous reading we filled it on.
And what is that number, 35647 above it?
That would be the reading,
And then that fourth column, what are those numbers?
the dates,
And
and the
then,
consumption is right above the date.
so where it says 93,
Correct.
what does that mean?
93 cubic feet. We estimated this particular account for 93 cubic feet.
And roughly how much water is that?
93 cubic feet is about,
You don't know how many
I
gallons?
didn't hear that. I didn't hear
no,
that.
it's 7.5 gallons to a cubic foot, so.
Okay, so then, directing your attention to page 2 of this exhibit, the entries in the second to right column either say EST or they say, there's some that say, there's one that says CST, third from the bottom.
That would be customer reading.
What is that mean?
It means the customer called us a reading or gave us a reading on the yellow card.
So then, going back to page 3, let's see, I just want to see if I understand this correctly. Page 3 that we were looking at one point it goes from auto would have been when the truck read the meter. Correct. Then it goes to EST, that means that would have been starting with estimates on the read. How do you decide, like, what would have made that change from truck reading to an estimated read?
In the event that we don't retrieve a reading or the PERT is not communicating with the system, instead of it sending over us a reading, we will estimate it. Sometimes after several attempts of trying to contact the customer, we do estimate the accounts to get their attention to see if we could possibly try to want them to call us to communicate to let us in.
So is there a bill generated every month and based on, is there a bill generated every month even if you can't get a reading on the meter?
Yes.
Okay, so am I correct that the truck read you approximately April 23rd and then thereafter, at least on page 3, going up to the top, those are the estimated readings, correct? What would be at the top of page 3 and the bottom of page 2? So then what is that entry that you said it was a customer, and that's, the date is October 25th, 2023?
That's the customer's reading. Somebody gave us a reading of 35461.
And is that reading the same as it was all prior to that, going through the next page? Like would that would show there's no water usage, correct?
Correct. When the reading stays the same, there shows no water usage.
Okay, so then a customer, do you know who that would have been on this meter? If the customer called and actually gave you a meter read on October 25th?
We can only take it as a customer read based on whoever has access to inside the property would be calling it in. I don't know.
Then what does that negative 186 represent?
That the previous estimates were overestimated.
So that was that, so then was there an adjustment made to the meter read then at that time?
Let me see. Sometimes if it's less than the minimum bill, it does not get adjusted, but sometimes it does, so yes. In this event, it was, adjusted because the next bill was $14.74, and at that time, the minimum bill was $62.78.
So was the truck ever able since October of 2023 to get a reading from that unit?
The ones that say auto, that was the reading that they picked up. In some events, if it did pick up anything, then it, was estimated.
So what happens then when the truck doesn't pick up a reading? Do you take any action with respect to the property?
We try to contact the customer. We try to send out, like I said, the little yellow cards, the big yellow cards. We call a phone number that is listed on the customer's account to try to speak with somebody to call us back, and occasionally they will. Sometimes they don't, sometimes they put a little note with the reading on it, sometimes they bring them up and deliver them, but we try several ways to contact the person.
When you send out bills, do the bills match the information at the top of this history registry as far as the address and the customer name? So this bill would have been going out with 14633 Gibbons Court in Napoleon Harris vacant?
Yeah, well, not the whole time, but yes. Before it was Napoleon Harris, and then it was Napoleon Harris vacant.
When was it converted to say Napoleon Harris vacant?
What document is
Do you know, can you answer that question without referring to anything?
Abnormal report.
Okay, so can you, when I ask you that question, can you answer that question with me without referring to a document, or do you need to look at a document to refresh your recollection?
I would need to look at a document that was
Okay.
4 years ago.
So, can you show me what you're looking at?
There's 2 months, 2 separate months. Well, the only one says February to March, the other one says March to April. This one appears on both of them. And one has it without the rate, and one has it with the, that one is the first bill that went out.
Well, hold on, is this
No,
on the record or off the record?
No, this off the record. I'm just trying to figure out,
Just trying to figure out which
what document you're looking at.
We'd like to figure it out too, so we can get that.
I know she's got one.
So I know, it's after the council gets
This
through,
one is from
telling
our
you what
zoning
it's
room,
about to
this
say,
one
can
is
we
from
see what they're looking at?
Yeah, I'm trying to figure what she's looking at, so I can get that to everybody. I have a stack of documents that I've just been given by her.
Whoa,
whoa.
Wait a minute. Back on the
Judge.
Okay.
So these documents were not in the records that you
No,
forwarded to
no,
us?
they just asked what she's reading from. I haven't had what she's reading from. They were just produced to me now to refresh her recollection. So, well, I did not know of this evidence until now. And it was at their request that she identify what she's looking at. So that's what I'm trying to piece together to refresh her recollection.
These are the monthly.
I'm gonna object to this going on. They've done their evidentiary disclosure. Those are the documents that we have. And any new documents that have come in, it's just totally inappropriate.
Well, I think
I
everybody's
totally
gotta
agree.
have a chance to look at them before we rule on the objection.
I'm looking at, I've been handed 2 sheets of documents that just don't have this address on it. It has other people's information, their account numbers, for water usage in the city park.
And I'm not necessarily moving you to admit this. You just said she needed them to refresh her recollection of other documents. So, can you tell us what are these documents?
Did we get a chance to see what you?
Yeah, hold on, I still gotta pass these over. Oh, there are multiple copies, I see. Ms. Craig, are you marking this?
I wanted to ask her, like, she said she needed this to refresh her recollection, if you're in the direction you guys wanted to see it, so.
Well, I think it should be marked as with some form of identification.
Okay, so let's mark this as plaintiff's exhibit 4. Okay. May I ask any questions about this one? Could you read the question that I asked her?
So how, I'm confused, why do we have so many copies if they were just provided as?
I didn't know how many. Are you asking me, can I answer that?
No, I'm asking the board because I'm kind of taken aback is that if she's refreshing her recollection from her records, it would just be the records that she brought with her today.
Do you guys have a response, or how did you guys get all these? You brought the copies? You brought extra copies of everything?
I was at work till 9 o'clock last night sending out bills. And while I was there, I was going over my ad reports. And I went to go see back when the vacant lien came on here. It was late, so I made just random 6 or 7, I think 6 copies of each one of these, which I didn't have a chance to discuss with this board, and I just thought that I would make some, if it could even be admitted if you can't.
Okay. What is the board?
Well, it's dust.
Because I think that the information is relevant. Unfortunately, the candidate's counsel didn't have a copy. So I am just followed.
Well, normally our evidentiary situation, if there's later discovered evidence.
I would also note that the references, there's one reference on each page for Napoleon Harris. And they are outside the time limit that we've been discussing, December 5th, 2023 to December 5th, 2024.
The only
I
question.
think the purpose of her bringing this in, and correct me if I'm wrong, is to establish when the coding on the account went from regular to vacant.
Exactly.
Which just said Napoleon Harris, and then it changed to say Napoleon Harris.
That was the question that I asked her. And she didn't know about looking at this, like why it was converted to marked vacant. That's what I wanted her to answer.
My question then is, it's still coded as vacant.
It was, that's on the previous exhibit that I gave you that was attached to the. Sure, when did it get marked vacant? She couldn't recall without looking at these documents. So, can you answer that question without referring? Can you answer that question without referring to anything? Oh.
When it was converted to saying Napoleon Harris vacant.
No, I cannot. I don't remember off the top of my head.
Do you know, now that you've looked at the document, do you know what date or what time period it was converted to say Napoleon Harris vacant?
This doesn't show an exact date, but I will state that May 1st bill of 2023 indicated the name Napoleon Harris vacant, and the previous one that was dated April 1st of 2023 just said Napoleon Harris.
What is the reason that the city of Harvey would mark a vacant designation on somebody's water bill?
Because somebody wants the water left on, and we may still get the same reading, so somebody would inform us that it's vacant, but don't close my account.
Would that information come from the customer, or would it come from someone else?
Objection as to whether or not this witness has been testified that Napoleon Harris called them to shut off the water, call it vacant, do it automatic.
I don't think it matters who called, but the fact is that that address doesn't have somebody.
I think your objection is premature, Mr. Levis.
Can you answer that question?
What was the question?
Would that information come from the customer or someone else?
Over the phone, I can't tell you who it came from, but it would be somebody that would have something to do with that property. They wouldn't know to call unless we sent my card out.
So I guess what I'm trying to figure out is when it's designated vacant, is it always originated by a property owner, or is it designated by someone at the city? Or could it be both?
We won't, just as the city of Harvey, we won't put vacant.
Okay. All right, I'm going to show you what I have displayed as exhibit number 4.
This was marked 4.
This would be marked 5. And I previously had given a copy of this to council. And ask if you can identify that document.
The top document is a work order.
And could you explain what a work order is?
A work order is how we communicate with the gentleman on the outside. The billing office, who bills, will prepare these work orders when we want a paper trail or when we want someone to go and do a work at a property. It's multiple reasons.
Okay, so what does this work order inform the city related to this property? And what was the date of this?
Yes. July 12th, it was scheduled for. It's a work order for a reading only. It indicates that there's a debox, the gentleman could not get a reading. And called and said he would email reading.
And was an email ever
No,
sent? How do you know that?
because I have no emails for this. Regarding this.
All right, can you explain us what the next page is?
A comment, and this particular comment was noted on the customer's account by a clerk, and it says yellow card issued on 3/14/24 per abnormal report.
And is there a copy of the yellow card that was issued in here, or is that the work order, or?
the yellow cards are door hangers. It's not in the pile I have. Normally they go out and the guys will try to get a reading from the customer or leave it for the customer to put a reading on it and send it back.
Okay, skip the next page, which is beyond the date here, and then can you tell us what the next page is?
A picture of the meter.
Can you explain what those notations at the top are?
Hold on, but it says the account number is the 008. The reading was the 035461. The address is 14633 Gibbons Court. And it looks like 62623. I'm not sure it's cut off. A part of it.
Could it possibly be 102623, because that would correlate with the customer adjustment, or?
It definitely cut into.
And then can you tell us what is on the next page?
Actually, this would have probably gone out before this picture of the meter. So we're letting this person know that we need to inspect the meter to see if the meter's connected, if there's a straight pipe, is there a meter there? So we want to get in, and that was issued on the 25th. And if this is the 26th, that means that somebody let us in to the property, get a reading, or to look at the meter.
26th of what?
October 26th, 2023.
So if you look at page 6 of that, is that a sample of the type of notice that goes out?
This is.
And then the next page after that, what is that document? The one that's dated 12/18/23?
That is also an inspection for us to get inside, for us to get inside to check the meter.
So how many requests have there been to inspect this meter since December 5th, 2023, as far as you know?
I don't know off the top of my head. Since 2023.
Could you speak up, please?
I don't know, exact number off the top of my head.
Exact number of what?
Please, Jerry, lend your turn.
Oh, sorry. Can you read back the question?
How many requests have there been to inspect this meter since December 5th, 2023, as far as you know? I don't know off the top of my head.
And then directing your attention to the last page of this document, can you tell me what that document is?
These are the readings that were retrieved or entered on the person's account from February 7th of 2023 to January 10th of 2023.
What were those dates again?
It's the last page of this document. So it's
Last page is this. Oh, got it. What documents? That's not even,
it's not the new last page.
last page is, oh, there's stuff to do.
So then, based on this information, and only from the time period from where it says December 11th, 23 to date here, have you ever been able to get a reading of the meter of that house?
No,
How do you know that?
these are all estimates.
And were there requests sent for a reading?
That's what the yellow card would have been. Can't tell on these, but the yellow cards mean that they're inspections requested of the meter. Some of these are red cards, which mean we're notifying you that the water could go off because we need a reading or past due amount. So on December 18th of 2023,
We only are concerned with that one, and those exhibits, you don't have to go farther back.
oh,
And then, all right, so after December 18th, 2023, did Harvey ever hear from a property owner related to getting a reading on this meter? Has anyone ever requested in that time period to have the property not marked as vacant?
No.
And have you had situations before where you've sent out bills that have the vacant nomenclature on it and then people have requested to have it changed later?
Can you repeat the question? I can't hear it.
We've been in situations before where you've sent out bills that have the vacant nomenclature and people have requested to have it changed later?
Yes.
Under what circumstances does that happen?
Objection, relevance.
Second.
All in favor?
Aye.
I have several people that leave for the winter, so maybe they don't want their water shut off and the property's heated. So we will get the same reading, so they know that we will get the same reading monthly. They don't want us to close their account for no activity, but they want it on for when they return. So sometimes it's from November to March, but they will call us back and say, okay, we returned home. It's not vacant anymore.
I have no further questions of this witness.
Ma'am, you're not here pursuant to subpoena, is that correct?
I beg your pardon?
You didn't get served a subpoena in this case, correct?
No.
You just happened to show up. Is that your testimony? I'm sorry, I'll rephrase that. How did you come to be here today?
I supplied some of the documents, to the person that asked me for them, and I had a meeting with my supervisor yesterday.
Okay, who was your supervisor?
Maria?
Okay, and did anyone from the city of Harvey tell you you have to be here today?
From the city of Harvey,
Yes.
Miss Carrie Lynn?
And she's the attorney for the city of Harvey, correct?
Yes.
And with regard to exhibit number 3, this is a printout, a summary history record for 14633 Gibbons Court, correct? I'm going off of your markings.
I didn't mark it.
Oh, this one.
Exhibit 3. And this is a document produced by the city of Harvey, correct?
It's produced by the computer system from BSNA.
And so you were talking about types of meters in which the vehicle could drive by and read the reading, correct?
Yes.
And those are all reflected as auto, correct?
Yes.
And in March of 2023, they could no longer get an automatic reading from the meter, correct?
That's what it appears to be, yes.
And from that time forward, the city of Harvey could not get an automatic reading through a I'll call it a drive-by. Is that correct?
Yes, correct.
And
It's actually May of 23, May 20th of 23.
And that's indicating there's a malfunction with the meter, correct?
No.
Well, if the meter's communicating with the car that drives by, there's a transponder on the meter, correct?
Yes.
And what that's indicating is they're not getting any readings from that meter.
Yes.
Okay. And with regard to the time period, so from the period of March of 2023 forward, your equipment was not reading the signals because no signal was being sent from the meter, correct?
Okay, so the ERT, which is attached to the meter that was installed at the beginning of the time that we were installing meters, were anticipated to work for 8 years. That does not mean the meters malfunction. We have a lot of meters that are functioning well. The responder is not sending over the reading anymore.
So the equipment that was, the city of Harvey installs the equipment for the water meter, correct?
Most of them.
And the ERT, the transponder,
Yes,
is also installed by the city of Harvey, correct?
correct.
And your records verify, and your testimony verifies, that there was a problem with the transponder reporting what the actual water usage was at the city, at this residence in Harvey,
That's
correct?
actually, that mischaracterizes her testimony. She said that was one of the reasons why they would indicate another solar.
Great phrase.
why don't you tell the electoral board all the reasons why the transponder would not be transmitting properly?
Somebody could cut the transmitter wires, especially on the inside that we have no access to. Some people have disconnected meters that do not respond to our communicating device in the vehicle. Some may be removed, some may be stolen, some may be at other properties. There's several different reasons why ERB would not send over a reading.
Do you
If
have
the
any-
wires are cut, we wouldn't get one.
Do you have any evidence that the wires were cut from the meter that is at this location?
No, not as of the date on the picture. They were not.
And the date of the picture is approximately what? You said it's 23. We don't have the first.
It was cut off October 26, 2023.
When you say cut off, it's the number,
The
not the
number.
wires, correct? And with regard to the city of Harvey, is there any notifications in your file advising Napoleon Harris there's a problem with our equipment?
There's not a problem with our equipment,
Well, the ERT is your equipment, correct?
not inside the home. The homeowners are responsible for the meters and the ERTs inside of their building.
Did you ever tell Napoleon Harris, is there any documentation, there's a problem with the water meter or the ERT in the building?
I don't believe we ever spoke with him, but those are what the yellow cards are for, to tell them we need to inspect it. We can't tell them there's a problem until we inspect it. We were not able to inspect it.
With regard to issue testimony today, it's fair to say that the city of Harvey does not know what the actual water usage was at this address during the time period of December 5, 2023 to December 5 of 2024.
Correct.
And in fact, the water usage could be tens of thousands of gallons, correct?
Correct.
Now, did the city of Harvey send bills to this account?
Yes.
And the bills have been paid, correct?
To my knowledge, I just looked at it.
Well, one of the documents, I believe it's Objectors Exhibit number 3, shows bills going out, and the bills are being mailed to 14633 Gibbons Court, Harvey, correct?
Correct, there's a zero balance.
And it shows multiple payments during this time period from December 5, 2023 through December 5 of 2024, correct?
Yes, that's why there's a zero balance.
And with regard to vacant, you testified earlier that when you got abnormal reports, the city of Harvey would treat that as vacant. Do you recall that testimony?
Beg your pardon?
You testified that when there was abnormal readings that the ERT system would give, the city of Harvey would declare or list that as vacant. Do you recall that testimony?
We don't declare anything, I'm sorry. Go ahead.
With regard to vacant, you have no communication from Senator Harris in your files indicating that he requested that vacant be put on this
I
property.
can't
correct?
identify a person over the counter.
Well, did you ever have a conversation with anyone with regard to this property?
I may not have, but whoever commented on the screens that were given to you in exhibits, there was, a clerk in there that commented the screen that day that she put it on there.
But there's no indication on that screen, because you've not produced the document, correct? Showing the screen report for that day?
I have to get more attention at this point. I don't know if that's one of the comments on here.
Sorry, I couldn't hear what the witness said.
I'm not familiar with the whole package, what was submitted or not submitted, so if there was comments put on there, it would have been put on by somebody who received the phone call.
But there is no records that were produced so far indicating that anyone made a phone call to the city of Harvey, they have this property listed as vacant. Isn't that correct?
I don't believe there's any paperwork.
I'm gonna show you what is Kansas exhibit number 7. And I'll ask you questions. For the record, I'm providing with a copy, copies for each board members, and copies for the attorneys. Do you recognize this document?
This is what document?
Kansas exhibit number 7. Do you recognize this document?
Yes.
And what are these documents?
Water bill,
And what are the water bills for? What property?
14633 Divins Court,
And who are they addressed to?
Napoleon Terrace.
And these are documents prepared by the city of Harvard, correct?
Yes.
And this is a document that you're familiar with, correct?
Yes.
And this is prepared in the ordinary course of the business of the city of Harvard, right? In the ordinary course of the city of Harvard, the water department? I would move Kansas exhibit number 7. Evidence?
Any objection?
I agree. So moved.
Second.
All in favor?
Aye.
Submitted.
I have nothing further.
I just have a couple questions based on this last document here. If you turn to, let's see here, page 3, after the apparently is for the period of 2/7/2023, 3/9/2023. At the top of it, it says Napoleon Terrace vacant, correct? Correct. Do you have any indication that Mr. Harris called at any point after that date to tell the city to not mark the property as vacant?
If it still says vacant, nobody notified us of it not vacant.
I have no further questions, and I would move to admit exhibit 3.
If I may.
Oh, sure.
Ma'am, with regard to the exhibit, I want to make sure the board's clear here. Just because it's listed vacant doesn't mean that water is shut off, correct?
No, it's not off just because it's marked vacant.
And water is still being provided today to this address by the city of Harvard.
To my knowledge, yes.
I know.
Nothing further, but I would move to admit exhibit 3. And the pages of exhibit 5 that are updated after the applicable dates here.
And what about exhibit 4? Are you doing anything with that?
Sure, 4 also then.
It's inappropriate, it was used to refresh your recollection.
Okay. What does the board want to? Well, let's rule on each one, or the board should rule on each one separately then, if there's an objection. Okay, so plaintiff's exhibit 3, which is the water readout.
History.
Okay, we've got a motion to admit it.
Second.
All in favor?
Aye.
Okay, plaintiff's exhibit 3 is in. As it relates to the exhibit 4, which was in fact used to refresh the recollection of the candidate. Candidate's counsel has stated an objection to that, moved to refresh the recollection of the witness. Candidate's counsel has stated an objection to that. That's that document, correct.
I'm not really sure what candidate 4 is, because I thought one of them was crossed off.
4 is this one.
Got it. Thank you.
So, what does the board want to do on that?
And say if it came in late, then it is not admitted.
Okay, so motion to deny admission. Do we have a second on that? If I may, the information that I think that they were trying to show on the plaintiff's exhibit 4 is, somewhat shown also in candidate's exhibit 7. It shows that, I think that the purpose was to show the date that it went from showing not vacant to vacant. And that's,
Admitted into evidence, but included with substantive record because it was used for that way. Yeah, just for the record for future review.
Well, like I said, I mean, I think that information, if I may though, that information, because all plaintiff's exhibit 4 was submitted for, was for the purpose to show that in February of 23, that it didn't say vacant. All right. All right, so we've got a motion and a second to not be admitted. All in favor?
Aye.
And just to clarify, is it still going to be in the record for appeal?
Yeah.
That which is
I
what
would
you were
hope
trying-
so. That's
Yes,
what I
that's
was-
what you were saying originally.
So that anybody who looks at it later can know what the witness was referencing. That's not evidence for us to consider beyond her testimony or testimony was. Move admission of number exhibit 5.
Second.
All in favor?
Aye.
Okay, those exhibits have been either admitted or made a part of the record as stated. Is the witness excused?
Can we question?
Oh, I'm sorry. Yes, absolutely.
My question for this unit is there an HOA that pays any part of the water bill for that building?
An HOA, to be more clear,
Homeowners Association?
not that I'm aware of.
So there's no separate bill going to that complex of townhomes to their association? And can you clarify this, charge of around $61, $62, $63? Would that be typical in a townhome?
That's a minimum bill. That is a minimum bill for having water on. And it is a typical bill from using no water to 267 cubic feet. The rate is based on cubic feet, and it is increased 61, 62. Every time Chicago raises their increase, that might be where you see the different amount. The garbage is $26.76. The sewer is $10 a month plus 16% of the consumption, and there's an admin fee of $2. That will be the total of your $61, $62.
So is there any way to make 267 cubic feet a meaningful number to me that knows nothing about quantity of water?
As far as gallons, as far as gallons, like.
Well, you have, I mean, I don't have my phone, so it's 267.7.498, I believe.
Wait, what is that?
Yeah,
If
like,
it's
you
200
estimate how many does it take to take a shower?
I'm gonna check.
That's a minimum amount of
Okay, so
water,
that's the
is
question
from
that,
0 to
just so we can be clear
267.
that that's a question from the chair now.
Can a family shower and do dishes and use that much water?
Everybody uses water differently, and it
There's
depends
no
on what's
magic
going on at the
typical
house.
number.
But these repetitive amounts are just the basic without knowing
That's a
exactly
minimum
what was
bill.
used.
That's a minimum bill for having water on.
But I mean, the same thing with water, sewer, refuse.
Correct. Those are flat fees except for sewer, it's plus 16% of the consumption.
For the board, yeah. Anybody's going to that.
So there seems to be a gray area that I can Steve point out that we don't know if they're really using the minimum or you're estimating that.
If it says
because-
zero,
Minimum,
zero. We never know what they're using unless we get inside and get a visual on it meter.
Which you haven't done for all those estimated bills.
Any other questions by the board?
No.
Okay, may the witness be excused?
Yes.
Thank you.
Thank you.
Okay, objectors, your next witness?
Could we ask for a brief recess?
Sure.
You're gonna have.
20 seconds.
Maybe.
We're back at 3? It's 2:50 right now, 3 o'clock.
27 cubic meters.
Give everybody 10 minutes, get up, stretch their legs.
So anyway, Nick, you can get with him real quick. It's all like, in general.
All right, y'all. I appreciate everybody checking in. Gotta get up out of here and go make this money. Cause I don't grift. I work for my living. And those that gave out of the kindness of their heart, I really appreciate you. I thank you from the bottom of my heart. I thank you for hitting the like button, supporting me, and sharing my videos. Keep tuned in, and we'll see you at the next meeting. Or check us out on Sundays when we do spiritual service Sundays, every Sunday at 8:30 p.m. Bringing a powerful message that will move your heart, save your soul, and change your life. Until next time, God bless everyone, and always remember this: love God first, love yourself, then you can love somebody else. Until next time, we'll see you. Reality Check TV, Chicago.
Full specs.